right, good afternoon, everyone, and thank you for joining us for the 2022 Municipal Leaders Roles and Responsibilities Seminar. My name is Adam Brome, and I'm an Administrative Coordinator with SARM. We will start off today's seminar by going over some key functions of the team's platform. Next, we will hear a few words from the SARM President and the RMA Vice President. We will then transition into the main presentations. Each presentation will be followed by a brief Q&A session. In addition, this webinar will be recorded and a copy of the recording will be available to view on our webinar's webpage following today's event. And as always, please let us know if you're experiencing any technical difficulties during today's webinar. You can let us know through the chat. The chat box is located on either the top or the bottom portion of your screen. You can click the message bubble icon to view or participate in the chat. And remember, this chat is visible to all webinar participants and presenters. The chat is also where you can submit any questions that you may have for the Q&A sessions. If we run out of time before your question has been asked, our presenters will follow up with you directly offline after the webinar. Please note your questions will be visible to all participants and presenters. So if there is anything that you would like to ask offline, please forward those questions to the appropriate presenters or SARM staff members following today's seminar. Please let us know if you would also like copies of the webinar presentations from today, and we will forward those to you directly by email. And again, if you're experiencing any technical difficulties, please let us know in the chat and we will do our best to troubleshoot. And now, without further ado, I will hand it over to Destin Reich, SARM's Manager of Programs, who will be moderating today's webinar.
Thanks, Adam. So yeah, hi everybody. It is a real pleasure to be able to host this webinar today. I'm pretty excited about the lineup of speakers that we have today. In addition to hearing remarks from SARM's President, Ray Orb, and the RMAA Vice President, Sheila Kaisig, we've also got a really great lineup of speakers to talk about different topics of particular interest, especially for newly elected officials, but also for those who maybe got some experience under their belts and need a refresher or would like a refresher on some different skills. So right after Sheila's remarks, we're going to hear from Judy Kanak about municipal leaders' roles and responsibilities. Following that, we've got Scott Cruickshank from the Ministry of Justice Dispute Resolution Office, who's going to talk about constructive conflict resolution for municipal leaders. And then finally, we're going to hear from Brenda Maximuik from the Procurement Knowledge Center, Ministry of SaskBuilds and Procurement, and she'll be talking about procurement best practices for municipal councils. And so, before we get into those sessions, we'll begin with a video remark from Ray Orb. And so, Adam, I'll invite you to turn that video on when you have a moment.
Welcome to the Municipal Leaders Roles and Responsibilities Workshop, a module of the Municipal Leadership Development Program. I'm Ray Orr, President of SARM. On behalf of SARM, I'd like to take this opportunity to thank you for choosing a role in local government. You've all made an important decision to serve your municipality and take an active role in guiding its future. Local government plays an important role in all of our daily lives, not only the lives of the ones holding a seat at the table, but the lives of the general public as well. An educated local government is a strong local government, so thank you for being here today to learn about the roles and responsibilities of being a municipal leader. The MLDP provides current and essential information on a wide range of topics, all relevant and developed specifically for Saskatchewan municipalities. Reeves, councillors, and municipal staff are able to benefit from this program that's designed to strengthen local government leadership. This fall marked the 19th anniversary of the MLDP, and the first modules rolled out in October of 2003. And since that time, there have been over 425 MLDP workshops with over 5,700 municipal leaders attending one or more modules. Today's workshop is just one of the 6 currently offered. On the MLDP website, you'll be able to review all the modules available through the program. MLDP modules are offered in various formats, including in-person, online, and virtual. I encourage you to take the modules that will benefit you as a member of local government. Lisa Shorty, the Program Administrator, is on the webinar this afternoon. Please contact her by email or telephone if you have any questions or would like to discuss the program with her. Her email address and telephone number will be listed in the chat. In recognition of your attendance, each of you will receive a certificate of completion and credit in the program. The certificates will be emailed directly to you. Today's session will conclude at 4:30. I hope that you'll find it worthwhile and the information useful. I want to thank our presenters and everyone for joining us today. We hope you'll attend another MLDP module soon. Our next speaker is Sheila Kiesek, the Vice President of the Rural Municipal Administrators Association. And Sheila is also the Administrator of the arm of Telemet number 216.
Welcome to all elected officials. Today provides an excellent opportunity to get a glimpse of SARM's programs and provides a refresher for many of you who have been on council for a longer time. I commend all of you for your commitment to your communities and to rural Saskatchewan. I also want to take this time to thank SARM for giving the RMAA a chance to talk about our association and the role we play in the day-to-day function of your RM. I'm Sheila Kiesig, Vice President of the Rural Municipal Administrators Association, or RMAA as we call it. I was elected to this role May 2020, and I'm the administrator at the arm of Telemet number 216, where I've been since 2005. The RMAA just recently celebrated its 100th anniversary in 2020. We were able to celebrate in person this past May. This is a huge milestone for our association. The RMAA has an excellent working relationship with SARM. We have worked together on many projects with both associations, seeking each other's knowledge and expertise. One such initiative we began as a 2-year pilot project in 2020 with the help of SARM is securing funding through the Targeted Sector Support Initiative. We are applying again for this to be an ongoing program. Our project, recently named AMP, or Advanced Mentorship Program, is focused on newly hired administrators. Our coordinator, Jill Palachuk, and advisor, Don McCullum, reach out to new administrators to see how they are progressing in their new roles. Don then has a series of phone calls with each administrator that wishes to participate. The feedback from this has been exceptional, and we're hoping this pilot project turns into an everyday tool that we can use. The AMP program will greatly benefit the administrator, the council, and your entire RM. Annually, we meet with SARM to discuss salary negotiations. SARM has endorsed this schedule continually for many years, but it also must be mentioned that this salary is based on your average RM. The salary schedule is negotiated in an open and honest atmosphere between the RMAA and SARM. It is our hope that the salary negotiations between your council and your administrator will also be conducted in the same open and fair manner. Another unique part of our relationship with SARM is that SARM's president has a place at our board as the ex officio director, and in turn, our president sits on the SARM board as the ex officio director. The differing views and knowledge that is brought to the two tables is invaluable. At this time, I would like to acknowledge the RMAA executive. Division 1, Cheryl Barrett, RM of Martin, number 122. Division 2, Kathy Ripplinger, RM of Pence, number 160. Division 3, Raylene Packett, RM of Webb, number 138. Division 4, Barry Bitston, RM of Keys, 303. Division 5, Doran Scott, RM of Blucher, number 343. Division 6, Michelle Beekler, RM of Peyton, number 470. President Guy Legradger, RM of Redburn, number 130. Past President Wendy Gouda. Director ex officio and President of SARM, Ray Orb, Reeve of the arm of QPAR, number 218. Our Executive Director, Rose Zimmer, arm of Wolseley, number 155. And myself, Vice President. I want to touch briefly on certification for rural administrators. It is legislated that each RM have a certified administrator hired. Administrators must be a member in good standing of the RMAA in order to work by obtaining the proper certification. To receive a certificate, the person must meet the specified educational classes and in-office hands-on training requirements. Each member must be current in their annual professional development hours to be considered in good standing. The RMAA strives to deliver the most up-to-date workshops and seminars for our members. It is imperative that council encourage their administrator to attend workshops and conventions to stay current on legislative changes, grant opportunities, and so much more. Likewise, it is key that you, as elected officials, take part in learning and networking opportunities to enhance your capabilities and benefit the municipalities that you have elected to serve. The resources that SARM, RMAA, and government relations have for newly elected council members is readily available and are excellent tools for you to use in your new capacity. I encourage all council members to ask questions to your administrators. We love nothing more than to talk about our jobs. I truly feel it makes for a better council member as well as a better working relationship when communication is open and honest. In closing, I want to say that the RMAA is prepared to assist councils and administrators wherever we can within the context of our mandate to do so. If you have any questions or comments, please feel free to contact any member of the executive. All of our contact info is on the RMAA website at rmaa.ca. I'd like to leave you with a short video our association and SARM work together on. It is a brief overview of an administrator's role in an RM. Thank you.
In 1914, the executive of SARM provided that a time be set aside in their convention for secretary-treasurers to discuss matters concerning their work. This arrangement continued until 1921, when the secretary-treasurers formed themselves into an associated committee, and in 1955, the association was constituted as a professional organization. The name was changed to the Rural Municipal Administrators Association of Saskatchewan in 1981.
To many people that live in the rural municipalities, the rural administrators are really the frontline people, the faces of the municipalities.
I was a city boy most of my life, and to become a rural administrator was a little bit challenging.
Everything that happens in a municipality does come through the office, whether it be permits or your taxes.
You are directed by council, but the day-to-day operations of a municipality are done by the administrators.
We're advising council, we're HR managers, we're planning and development officers, we're accountants.
You're ensuring that bylaws are in place because they're the guidance of your municipality.
You have to ensure that roads are being gravelled, roads are being plowed in the wintertime.
You're minute taking all your council meetings.
You're dealing with ratepayers who have concerns and making sure those concerns are addressed.
Your audits at the year end.
Speaking with other stakeholders, whether that be on the provincial or the federal level.
Especially in rural areas, we are on lots of different boards. We help out at rinks, we help out at schools.
As long as the community feels that they have a connection with the administrator, they feel that their needs can be met.
We all have a plan on what our day is going to be, but it can go out the door with a phone call or an email.
I enjoy coming to work every day. I enjoy dealing with people.
I like the office work. I like the accounting side of it.
Lots of opportunity for upgrading as far as training.
If you have the right qualifications, your career path would be a very long one.
It's not the same old mundane routine day after day.
That's what makes the job interesting, right? You're never bored.
If you enjoy working with people, if you enjoy working with finances, if you enjoy the challenges of meeting deadlines and the opportunity to serve the people of your community, it is a great career path to choose.
Well, that was an excellent video. I had seen it before, and each time I do, I'm reminded of how much I like working with our RM administrators in the role that I get to have. So right away here, we're going to hear from Judy Kanak. Judy started her municipal administration profession in 1984 as an assistant in an RM office. She became an administrator for a joint rural-urban municipal office in 1988. And after a 30-year career there, she joined the advisory services team with the Ministry of Government Relations. That was in 2017. And then she became that unit's manager in 2021. And so Judy's going to share with us an overview of municipal leaders' roles and responsibilities from the perspective, particularly of the acts. And she's going to touch on several pertinent issues that are critical for understanding how municipalities are to operate from a governance perspective. And so with that, Judy, I'll invite you to take it over and begin your presentation. We'll pause about 45 minutes in and we'll do Q&A at that point. Thanks, Judy.
Okay, thank you very much, Dustin, and thank you for giving me the opportunity to participate in this program today. So I will just ask everybody to be patient with me as I try to control two different screens here that I'm working on at the same time. So first of all, congratulations to all the newly elected council members. I'm sure you're going to find the next 4 years of your term of office very, very interesting. So here's an overview of what we're going to cover today. And as you can see, there's lots of information that we have to go through. And truly, we are just going to just barely touch the iceberg on a lot of these things. It's impossible to cover everything in the short amount of time that we've got here today. But that's okay. We'll get through it as best we can. And please know that we have resources available to you. So if you ever want to find out more, you can contact our office and we'll be able to answer your questions. Okay, so here are the top 4 things that I hope you'll remember throughout your term of office. Number 1, municipalities are a level of government. They've got a considerable amount of independence to govern within their jurisdiction. The Municipalities Act, as well as other pieces of legislation, explains that jurisdiction, and it expects that municipalities will act responsibly as any level of government should. The provincial government has very, very limited authority to intervene in local government affairs. Yes, there have been a few occasions where the province has intervened. You may have even heard about a few of those in the media, but those were very extraordinary and high-profile cases, probably the type of notoriety that most municipalities do not want for their own. Number 2, councils are required to conduct their business in an open and transparent manner. So your council meetings can be attended by the public anytime. And by public, it means anybody, not just your municipality's ratepayers. The public that elected you has the right to know what their government is doing. And council is accountable to them because of our democratic electoral process. You are local politicians. There are a few exceptions to the open and transparent rule, such as the ability to hold closed sessions and the duty to respect privacy laws, but we're going to discuss that a little bit later in this presentation. So number 3, council members are part of a team. Individual council members don't have the authority to make a decision on behalf of the municipality. If they do, they could be held financially or legally liable. Each council member is just one member of a team, which means the team collectively must work together to make decisions for the entire municipality. But I'm going to carry that just one step further. A division councillor has a duty to consider the needs of the entire RM, not just the needs of the division that they're representing. The division boundaries are really just used for the purpose of the electoral process, not for decision making. And the 4th thing to remember, resolution. This is the only way that decisions can be made. And the only way to obtain a resolution is by passing one at a properly called council meeting. Decisions cannot be made by email, nor can they be made by text message. So I'm going to share this graphic with you early in the presentation. Part of this program, I used to do it a little bit later, but it's my favorite slide. So I'm going to bring it forward early on in the presentation. I think it's really, really important to understand how trust is the foundation of every effective relationship. And if council members understand how trust works, you're going to have a successful term in office and a respected team. Now, if I was at a whiteboard, it'd be a little bit easier to demonstrate this graphic, but I'll try to explain it. Everyone starts with a stranger level of trust, and that's represented by the horizontal line in this graphic. Now, if you move over to the left side of that line, as you get to know a person, trust builds, so you're going uphill. But if that trust breaks by whatever action or decision, don't assume that the trust is automatically going to return to the stranger level of trust or that horizontal line from where you started. In fact, it does not. Because both parties put so much time and effort into building that trust, when it breaks, it's going to drop below the stranger level of trust, usually because of disappointment or because of shock. And sometimes it falls far below that horizontal line. Rebuilding trust can take substantially longer than the initial building of trust. This is because when trust is broken, people are hesitant to, or even reluctant to give others the benefit of the doubt. So what does this have to do with council? Well, I think the beauty of this graphic is that this concept also relates really well to the relationship council has with the public and demonstrates how important the public's trust is in their local government leadership. So let's look at what the purpose of a municipality is. Well, first of all, good government. That's making decisions that affect everyone in the municipality. People also want services and facilities. Part of your job is determining what is needed versus what is wanted. And then you have to figure out how to resource those services or those facilities. People want communities that are safe, obviously. And of course, you're going to want a municipality that is viable beyond just your term of office. And lastly, a municipality has a responsibility to safeguard and maintain its infrastructure and public assets. So as mentioned earlier, the Municipalities Act is the legislation that provides the framework under which RMs are to govern. The Act is not a guide. It is your fundamental rule book. Now, in many instances, you'll find in the Act the word shall. Shall, as it sounds, means these are your duties. For example, municipalities shall conduct their meetings in public, and they shall, they shall or they must provide public notice before they discuss certain matters. So when you see the word shall used in legislation, it means it's a required obligation. The word may is also used in legislation a lot. In fact, if you were to take a count, I think it probably outnumbers the word shall by quite a bit. So if may is used in the legislation, it means the municipality can choose whether or not to do something, or it's council's discretion. So whatever your council decides, be prepared to justify your decisions, should you be asked by the public why that decision was made. Legislation and the public expects everyone will be treated fairly, but the risk, not everyone is going to like it. So this slide goes a little deeper into one of the original top 4 things to remember. Municipalities are required to act through council. which means council must pass resolutions or bylaws or even policies at a duly called meeting. And to hold a council meeting, appropriate public notice must be given. There must be a quorum of council members present, and the administrator or the administrator's designate must be present. And as I mentioned before, individual council members cannot make decisions alone. They are part of a team, which is the entire council. So it's not acceptable to make a decision by email or text message, because emails and text messages take away the public's right to participate in their municipal government. And that's also not demonstrating openness and transparency. Decisions can only be made by resolutions. So if you need to make a decision on very, very short notice, it's probably best to call a special meeting, or if possible, even wait until the next regular meeting. In many cases, texts or email messages relate to operational matters. So if council just in advance sets some sort of policy, authorizing or directing their administrator to handle various operational matters, then you wouldn't be in this position to begin with. All right. What is an oath or affirmation of office? This is the prescribed form that you should have all signed prior to your first meeting after being elected. Prescribed means using a specific form provided in the legislation. So it's not a form just exclusive to your municipality or one that was made up by your administrator. Any member of council who refuses to sign that oath or affirmation has no right to participate in council debate or in decisions. The Act very clearly states, and I quote, "Every member of council shall, before carrying out any power, duty, or function of his or her office, take an official oath or affirmation in the prescribed form." Your administrator will have provided you with this form shortly after you were elected. Just make sure it's signed before your first meeting commences. So let's talk about public disclosure statements. The public disclosure statement has a direct impact when dealing with conflict of interest, and that we're going to discuss in more detail a little bit further down the line. It is also a public document, which can be inspected by anybody. Excuse me. This form is not prescribed in legislation, but it is mandatory to be completed. Your municipality will have adopted its own form for its council members to use. Legislation does require, however, that the form used by the municipalities contain certain information, and that information will be about the council member and his family. It will include employment, financial interests, business interests, and property holdings. Throughout your term of office, you're going to complete the public disclosure statement. Let me start again. There are 3 forms, but you will complete at least 2 of them throughout your term in office. The 3rd form may or may not be required for completion. So form number 1 is the main public disclosure statement. This one you will complete twice. You'll complete it first at the time of the election when you are being nominated. The form must be completed and actually form part of your nomination papers. The second time you complete it will be if you're successful at getting elected. You will complete another one within 30 days after being elected. You cannot use the same form that you completed when you were nominated. Form number 2 is the annual declaration. This annual declaration must be completed in years subsequent to the year you were elected and must be done by November 30th. And form number 3 is the amendment form. That one is only completed when the information on your original public disclosure statement changes. So for example, if you happen to buy or sell property, you are going to ask your administrator for an amendment form so you can make that change to your property holdings. Or perhaps another change might be that your teenage son gets himself a summer job at the local gas station pumping gas. That will require amending your public disclosure statement. So conflict of interest. This is an essential part of legislation, and all members of council need to be mindful of it. It's important to know that when a financial interest is involved, a conflict of interest always exists, regardless of the amount of money involved. It doesn't matter if it's $50 or $50,000. It's okay to have a conflict of interest. In fact, there's a very high possibility that many council members will, for sure, have one or more conflicts of interest during their term in office. And it's even more likely to occur in smaller communities where the pool of potential contractors that you deal with or the pool of potential employees is a lot smaller. So that's why it's very, very important for all council members to be aware of conflict of interest and know how to handle it. Council members are individually responsible for determining whether or not they have a conflict of interest. This is an ethical duty, essential to good government. It is not the responsibility of other council members to monitor and police your handling of conflict of interest, nor is it the responsibility of municipal staff. So don't ask your administrator if you have a conflict of interest. It's not their role to determine. As we mentioned earlier, every council member, upon signing their oath of office, swears or affirms that conflict of interest will be disclosed. We're often asked how to force a council member to declare a conflict of interest. And the short answer, you can't. But there are some steps or some options that you can use to maybe encourage appropriate behavior. So one of those options might be informally identify the concern by verbally asking that council member if maybe that matter might be a conflict of interest for them. Or you could formally raise the concern by making a resolution or filing a complaint under your Code of Ethics bylaw. Another option would be to request a recorded vote on resolutions. Then the minutes are going to show who voted for and who voted against a resolution. Remember, minutes are public. Anybody can see them. So that would be evidence for determining who was present during the decision making. And of course, there's always the option of using the courts. So how do you handle a conflict of interest? It's actually pretty easy. When a matter comes up before council that you have a conflict of interest in, or maybe you think you might have a conflict of interest in, just follow these steps. So number 1, declare. Number 2, disclose. Number 3, abstain. Number 4 is refrain, and number 5 is leave. If you like acronyms, the DARA might be easier to remember for you. Anyways, once council's finished dealing with that particular matter, you just return back to council chambers and carry on with business. Code of Ethics. Your municipality must have a Code of Ethics bylaw for elected officials. This bylaw defines how you as a council member should treat other council members and your staff and the public. The Code of Ethics bylaw will talk about honesty, which means council members must be truthful and open. It talks about objectivity, meaning decisions must be made carefully, fairly, and impartially. It will discuss respect. And again, that's for everybody. All council members, staff, the public, they must all be treated with dignity, understanding, and respect. The bylaw discusses transparency and accountability, meaning council business should be conducted in open sessions so citizens will clearly see how and why decisions are made. The bylaw discusses confidentiality. So when you are performing your office as a council member, there could be times where you are privy to some confidential information. You have to keep that information private. So the Code of Ethics demands that you be confidential for that information that should be kept confidential. Because as a council member, you can't benefit from information you learned in fulfilling your role as an elected official. The Code of Ethics bylaw also discusses leadership and public interest, meaning that you are going to serve your citizens and act in the best interests of the municipality. You understand that personal benefit, wrongdoing, or unethical conduct will not be tolerated. It also discusses responsibility, meaning all council members must act in accordance with legislation. They must disclose all conflicts of interest and follow the policies and procedures of your municipality. Also included in the Code of Ethics bylaw will be a process for dealing with breaches to your Code of Ethics. It will include remedial actions required of council members who do violate the Code of Ethics. Some possibilities for remedial action might be to apologize or to take training. So if you haven't already noticed, there's a very, very close relationship amongst the recent topics we've covered: oath of office, public disclosure statements, conflict of interest, and Code of Ethics. It's really all about being open and transparent. And I cannot stress enough how important these items are, because they are the #1 subject of most of the phone calls we receive. So this slide shows an example of what your municipality's organizational chart might look like. Except for stating that council is accountable to voters and council must appoint an administrator, legislation does not describe how your municipality is set up. The key thing to remember here is communication. When everyone understands their role, the municipality is more likely to function properly, smoothly, and successfully. When we hear in our office about a municipality having trouble with staff or even with the public, often the cause is because there's a weakness in this organizational structure. So the lesson to learn here: please respect everyone's individual role. So what about the voters of your municipality? Municipalities are accountable to their public and to their voters. The public has certain rights. The public can observe council meetings, as I said before, anytime they wish. They can come and watch and listen. They can access municipal documents, some of them just simply for the asking, such as bylaws, minutes, etc. The public can interact with council, either formally or informally, and they've also got the right to petition for such things as for and against bylaws or policy. They can petition for a public meeting of the voters. They can petition for a referendum. And they can petition for either a management or a financial audit. I put at the bottom of the slide a Citizen's Guide to Shaping Council Decisions. This is a document, a publication that our ministry has used widely. We give this document to many, many, many people. either by pointing it to them on our website where they can access it or emailing it directly. We also encourage administration offices to have copies of this document in their office, maybe if there's a place for literature at the front of your office, so that the public can pick one up if they choose. So the role of elected officials. The general duties of council members, you can see there, says that they have to represent the public in their best interest, participate in developing policies, programs, and services, participate in meetings, ensure there's administrative practices and procedures in place, keep private matters confidential, and maintain the municipality's financial integrity. Then there's the duties of the reeve, which really is not a whole lot different than the duties of other council members. In fact, they're basically the same, except for these 3 items. The reeve has the additional duty to chair council meetings. The reeve also has the ability to call special council meetings alone without necessarily having the approval of other council members. And the reeve is the head as defined under the Local Authority Freedom of Information and Protection of Privacy Act. And because that's such a mouthful, we say LAFOIP for short. But I think this slide is actually missing another very, very important duty. And that is elected officials or council members should not get involved in day-to-day operations of the municipality. Council members cannot be employees of the municipality, nor can they act as an employee. So that would be like a supervisor. Council members, you must remember, are decision makers. They are policy makers. They are not action takers. Leave the operations of the municipality to your staff. This is another important reason to have an organizational chart. The legislation requires every municipality to appoint a person to the Office of Administrator, and that person must be certified, as you heard Sheila mention earlier. There is a Rural Board of Examiners that determines the qualifications required for an administrator to be certified. An RM cannot operate without an administrator unless they get special permission by the Board of Examiners. So your municipality may need to provide notice to the public before council decides to discuss certain matters at a meeting. Some of the instances where public notice must be given are calling special meetings or calling rescheduled regular meetings. Public notice must be given when council is going to be discussing and setting or potentially setting council remuneration. Of course, for borrowing money, public notice must be given as well, and permanently closing a road. There are several more reasons to give public notice as well. Your municipality has a public notice bylaw that's actually required by legislation. So in that bylaw, you will see the details for how and when public notice is required in accordance with the legislation. The Council Procedures Bylaw for your RM will guide your procedures at meetings. This is, in most cases, a very large and comprehensive bylaw with lots and lots of information in it, including the few examples that are listed on the slides. When council members, or all council members, should be familiar with this bylaw, and it should be readily available for reference at every single meeting. That's just going to save you time should an instance come up that you are unsure of how to handle. As the slide states, this bylaw is mandatory for all municipalities to have. In fact, if your RM does not have a council procedures bylaw, your municipal revenue sharing grant could be in jeopardy of being withheld. And because that can be, particularly for rural municipalities, tens and tens of thousands of dollars, you don't want to be putting your municipality in that position. Council meetings. So with certain exceptions, all council meetings are open to the public, as I mentioned before, and that means anybody, even people who are not your ratepayers, of your RM can attend your council meetings. People have the right to watch their local government in action as long as they behave. That being said, this also means that anything discussed in a regular session of council is public information, so that can be discussed outside the council meeting. This relates back to the earlier slides about the top 4 things to remember and being open and transparent, and also that trust graphic that we looked at near the beginning. The more open and transparent council is, the fewer problems you will have with public trust. If the public wishes to address council, they can ask your administrator to be put on the agenda as a delegate. And the procedures for handling delegates is outlined in this council procedures bylaw. Some municipalities have annual ratepayers meetings. These meetings really are just for exchanging information. They're not for deciding municipal matters. They're not required by legislation, but they do work as a good PR tool. So this is also a good time to discuss the interaction of council members during council meetings. People who disagree are not necessarily in conflict. Debate is healthy, and it often leads to great discussions. Council members should communicate clearly and openly. They should provide input and respect the input of others. They must focus on the facts and confront conflict early instead of allowing it to fester and to snowball. So this leads us to closed sessions. Some people still refer to them in camera sessions. Our legislation calls them closed sessions, but they are one and the same thing. Council has the ability to close all or a portion of their meeting to the public. But please be careful how you use them, and also use them very sparingly. Closed meetings can lead to a lot of assumptions from ratepayers, including suspicion. And this does not help improve that building of trust we discussed earlier. And while there are some circumstances where confidentiality is important to good governance, secrecy will certainly weaken it. Now, that being said, sometimes there are sensitive matters that must be deliberated by council in a closed session. Council has a duty to protect personal information and some private matters. There's things like staff hiring or performance evaluations, handling of code of ethics complaints, legal issues. Those are examples of matters that you would go into a closed session for. I mentioned at the beginning of this presentation that there are many resources available. These resources are for council members and administration staff, and even the public often accesses these resources. First, the Municipal Peer Network connects municipal officials or administrators with highly experienced mentors who can provide advice and help resolve disputes. Mentors are a mix of council members and administrators who are trained in coaching, communication, facilitation, and dispute resolution. They can be reached by phone or met with in person. All conversations are confidential and they are free of charge. If you visit the website, you'll find contact information for the various mentors participating in this program. Next, we have the 10-minute trainers. These are free online training tools to help expand the knowledge of counselors and administrators. Each module includes short videos and questions designed to engage the entire council in discussions. There are 2 videos, one about the council procedures bylaw and one about the roles and responsibilities of council and of the administrator. And they can be found on the province's website as well. Speaking of the province's website, you will find a huge selection of guides and fact sheets. There's manuals, there's general information about all things municipal and on a variety of topics, including but not limited to a municipal council member's handbook. There's information on conflict of interest and public disclosure statements. There's information on community planning. There are various recorded webinars and so much more. Now, this website is quite large. So to get to the right page for municipal government, when you get to the provincial website, select government, then municipal administration. That's where you'll want to create a bookmark so that you can easily reference it in the future. And don't forget to check your association's website for additional information. The Ombudsman Saskatchewan takes complaints about municipal entities. They have resources available on their website as well that could be helpful to you in understanding the role of the Ombudsman as it relates to municipalities and for making and communicating decisions fairly. The Ombudsman's website also has great information about conflict of interest, including a checklist that municipalities can use to help themselves determine if they have a conflict of interest. It's a great resource that we use all the time. The Office of the Saskatchewan Information and Privacy Commissioner, or as we say, OIPC, oversees 3 Saskatchewan statutes, including LaFoIP, which I mentioned earlier. It ensures that public bodies respect privacy and access rights of citizens by informing the public, by resolving disputes, investigating complaints, and issuing recommendations. They also provide training sessions. And lastly, there is Publication Saskatchewan. Now, this particular website houses every publication that's created by every provincial government ministry or agency, so also a large site with much information on it. It also has all of the pieces of legislation in our province found there. And finally, you can contact us. Our office is always here to help elected officials, administrators, and also the public with technical advice about municipal government. So you'll see our inquiry line phone number there, as well as the email address that you can use to contact us anytime. And that's the end of my presentation. Dustin, I have no idea how we're doing for time.
We're doing great for time, Judy. Thank you. And thank you especially for your presentation. You do such a remarkable job of kind of giving us the big picture of the high points that are important to know about as elected officials and those who work with them. So this again, thank you for your presentation. I know there will be lots of questions. I see one already that's in the, it has come up to me in the question and answer module there. And I'll read that out in a moment. I'll just invite other questions to go into the chat feature. And so once you've put your question in there, you've typed it in, then Adam will flip it over to the Q&A area where I'll read it and ask Judy. And I would want to mention as well that as Adam said, what goes in those chat features is public. So you want to have some discretion with the way that you phrase your questions and things like that. So Judy, the first question I have here is during a public hearing, a councillor can declare their conflict, leave their seat, but can speak to the issue as an affected member of the public, pursuant to regular public hearing procedures. They don't lose their general abilities as a ratepayer, correct? Just need to establish a clear line between the two, and they can't be involved in the decisions.
Okay, so I need to back up a little bit here. Your question is about a public hearing. Our legislation does not talk about public hearings. We have public meetings, not public hearings. Public hearings are mentioned in the Planning and Development Act. So if you are talking about a public hearing for a matter under the Planning and Development Act, that is legislated through that particular piece of legislation. Now, I'm not an expert on the Planning and Development Act. We have a separate branch, our community planning branch, that are experts on that. Yes, you're going to have public hearings for community planning issues at your council meetings, but there are different rules associated with public hearings for community planning matters. Now, if you are meaning a public meeting just at a council meeting, there is a piece in the legislation. It falls under it's in the section about conflict of interest where it explains that a council member can step back as a council member from the table and form part of the gallery or the public, and yes, address their concerns. So you may want to visit that particular piece in the legislation just to find out what rules are associated with that. So yes, they can speak on that matter, but they can't participate if they have a conflict of interest in that matter as a council member. So I hope I made that clear. There is a difference between public hearing and public meeting.
Yeah, that's really helpful, Judy. And for those who are on the call, I hope Judy's answer there is evidence of the kind of expertise she brings to the table. So I encourage you to take advantage of the next few minutes that we have here to ask your questions. There is another question that's come up in the chat, and that is, can councillors attend committee meetings if they're not on that committee?
Most of the committees that council establishes are probably considered public meetings as well, just like council meetings are as well. So I think what you need to do is go to your council procedures bylaw. Typically at the back of your council procedures bylaw, there's a whole section that discusses council committees, and it will give all the rules around your committees and how they are to be run and who's involved with them. I know in most cases the Reeve is ex officio member of all committees, but refer to your council procedures bylaw. That could actually be a little bit different for different municipalities.
Great, thanks, Judy. Don't see any other questions at the moment. Maybe there's some being presented. Judy, I'm curious from you, what are some of the common issues that you and your team have come across with respect to conflict of interest? I know that's a really popular one, or one that they ask you about a lot. Are there some pretty typical scenarios that you've encountered?
Yeah, so the legislation talks about family when disclosing conflict of interest in your public disclosure statements. And the definition of family includes your spouse and your dependent children. However, you also may have a conflict of interest in closely connected persons. So closely connected persons could include your father-in-law, or maybe your adult child, or maybe even your best friend. So keep those connections in mind as well when you are considering whether or not you have a conflict of interest, because the public could perceive that you have a conflict of interest with people that are closely connected to you, and that's just as important as your immediate family members. So we always recommend and encourage people when they ask about those type of situations to take the high road. Why not declare a conflict of interest anyways, even if you're not sure whether you have one or not? Step out of the room, let the rest of your council members make a decision just for that one matter, and then you can come back and continue to participate. Then you for sure cannot be accused of having a conflict of interest and not declaring.
Yeah, I can see that being a topic that's pretty common as well. I did see another question come up, so I'll make sure that I defer to that one. It hasn't quite come through the Q&A session yet. There it is. So this one reads, does it need to be in the bylaw that a non-appointed councillor that attends a public committee meeting does not get remuneration for attending that committee meeting? Or is that obvious with the appointments to the committee by council?
Yeah, I would think, I mean, it's not really addressed specifically in legislation, but first of all, not all committees even pay any kind of remuneration. Some of them are considered voluntary, some of them are paid, so that can be different in different municipalities. I would assume that those that do pay remuneration to committee members would probably only pay them to those that are appointed. But again, if they want to pay anybody that joins, I guess that would be up to council. It probably should be stated in the council procedures bylaw to be clear, and then that would avoid any questions.
Yeah, that makes sense. I've got a little bit of familiarity with the privacy commissioner. Tell me a little bit about some of the cases that you've seen or have come to you with regard to public documents and disputes over which documents should and can be released and which ones ought to remain confidential.
Okay, so we deal specifically with those documents that are listed in the Municipalities Act. They're found under Section 117 of the Municipalities Act. It lists all of the documents that anybody from the public can just walk in to the municipal office and ask to either inspect or to obtain a copy of. So I touched on it briefly in my presentation. Minutes, people have the right to see minutes anytime they want. Now, they can't get a copy of the most recent minutes that have not yet been approved and signed, because that's, of course, going to happen at the next council meeting. But they can still look at them. They can inspect the unapproved minutes. Any minutes that are approved are available for the public. Bylaws is another common one. Any agreements that have been approved by council can be viewed by the public. Financial statements, of course, is something that the public can ask to see. Accounts paid, that's another big one. Accounts that have been paid, approved by council, the public have the right to see those as well. Anyways, if you have a copy of the Municipalities Act, navigate your way over to Section 117 and they're all listed there. Now, that doesn't mean other documents are not also accessible to the public, but they don't have to be given to the public just for the asking. Other documents, you have to make a request through LaFoIP, that Local Authority Freedom of Information and Protection of Privacy legislation. There's a special form that you have to complete, listing the documents specifically that you're looking for. Give that form to the administrator, and then they have, I believe it's 30 days to comply with that request. Then it is up to the head, which is the reeve, probably with the help of the administrator, because the administrator has access to all of the documents, the municipality's documents. They will determine which of those documents that are being requested are in fact available for that request, based on the restrictions given to them under LaFoIP.
Yeah, that's great. Thanks. That's a helpful answer. Any other questions for Judy? There's another one. Actually, looks like there's a couple. These will be coming up shortly. Now they're rolling in.
Yeah.
I must have said something that got everybody thinking.
And I'm not seeing them, by the way. They pop up briefly and then they disappear. So you'll have to read them to me.
I sure will. And that's exactly what's going on there. Okay, here it is. How should the administrator deal with reports given at a council meeting? Should that entire report be attached to the minutes?
That's up to each individual municipality. Again, you could put a clause in your council procedures bylaw, whether or not they are attached to and forming part of the minutes, or if they are to be filed. But if those reports are approved or provided to a council meeting, then chances are they could also be accessible by the public if somebody wanted to see them.
Great. Another question. Describe documents that, quote, shall or may, end quote, be included with tax notices. Please discuss financial statements and disclosure of council/employee wages. Thank you. So I think maybe what they're looking for there are
that first part, was the tax notices, documents
Yeah.
that are included, shall or may be included. That's not addressed in legislation at all. You don't have to put anything in your tax notice, but many municipalities do choose to include a copy of their annual financial statement because elsewhere in the legislation, your annual financial statement must be provided to the public. That's one easy way to provide it to the public in a very, very effective way by giving a copy in the tax notice. It prevents another mailing. There is an option to give annual financial statements in other ways as well, but certainly that's a popular method by doing it in tax notices. I know a lot of municipalities include newsletters if your municipality happens to create newsletters, but there is nothing that must accompany the tax notice by legislation.
Okay, and the second half of that question was relating to financial statements and disclosure of council/employee wages. I wonder if they're asking there more about whether or not that has to be disclosed or if it is more of a may question.
Yes, they can be disclosed, absolutely. The employees are basically civil servants. In fact, there is legislation coming down the pipe that will be dealing with public accounts. All municipalities will have to disclose public accounts. I don't know what the threshold will be for those public accounts. That hasn't, I don't think, been established yet. It's something the cities already have in place. I don't know what their threshold is either, but just for demonstration purposes, it may say that any contractor or employee that receives more than $25,000 per annum must be disclosed on a public account statement. So that's coming down the pipe. Absolutely. These are public dollars, tax dollars that you're dealing with. The salaries may already be in the minutes. So people can see them even by looking at the minutes.
Yeah. Yeah, it's really helpful. And related to that here too, and I think you've already answered this question. Another question that came through is, are ratepayers allowed to have access to remuneration for administrators and municipal salaries?
Well, I think that's kind of the same thing. So although we didn't touch on remuneration, so remuneration of council members, absolutely. They elected those people to make decisions to wisely spend their tax dollars. They certainly have the right to know what the remuneration paid is to council members.
And one last question here, or at least so far anyway. In the Municipalities Act, when a meeting is set for a set time and the meeting does not start on time, like a half hour late, then there should be no pay. Who does this fall on, mayor or question mark?
So that would be an individual policy, whether or not that individual council member is going to be paid for meetings that don't happen as a result of, I guess, a quorum does not show up. In your council procedures bylaw, there's probably some sort of policy for how long you wait after the meeting is opened for a quorum to arrive and whether the meeting is going to continue or not. And if it does not continue, good question. Legislation does not address that, but you certainly could create a policy locally to deal with that type of situation.
Great. Okay, it looks like our questions have slowed down here a bit. So Judy, let me just thank you again for your presentation. Thank you for taking time with us today. I know I especially have appreciated the advice you've been able to give me, even at SARM, as we've worked through some different kinds of issues about how to best support rural municipalities. Your team and yourself are available through the advisory services. There's a line, like a single line for access there, if I recall.
Absolutely. So 787-2680 is our inquiry line number. Please call us anytime. Leave a message. In fact, it's even more helpful to us if you briefly state in your message what your matter is that you'd like to discuss. Then perhaps we can do a little bit of homework before we quickly call you back and have all that information handy to provide to you.
Great. Okay, well, we're a little bit ahead of schedule, but I'll thank you, Judy, again for your presentation. And I'll invite Scott to join us on camera and we'll get him to load his presentation up. And there's
Thank
Scott
you.
now. Thanks, Judy. Thanks again. And welcome, Scott. Scott, you're going to be sharing with us constructive conflict resolution for municipal leaders and a little bit about your background. Scott works with the Dispute Resolution Office with the Ministry of Justice and helps people and organizations to have difficult conversations and develop strategies to assist them in reaching agreement or understanding. Scott has 22 years experience in the community and government as a mediator, trainer, facilitator, coach, and dispute resolution consultant. So I'm particularly glad to have Scott here with us. Scott and I have had the chance to collaborate on a couple of things recently, and it's in large measure because we're in a time and a season of our history where conflict seems to be particularly acute these days. And so Scott's skill set and his expertise are particularly welcome and particularly beneficial. I'd like to think that municipalities and all sectors of government were spared the difficulty of conflict, but I dare say that's not the case. So, Scott, we welcome you here, and I'll invite you to share with us your presentation today.
Great, thank you. Well, I appreciate having an opportunity to meet with you. We often get called in when conflict gets to a spot where it's very intractable and people are having lots of difficulty. And so part of this discussion or presentation will be a bit of a sampling or a platter that you might get at a restaurant that will talk about a lot of the main concepts in conflict resolution, some that might pique your interest. Hopefully they may give you some insight on managing relationships and conflict, and or give you a sense of where you may want to look and get more understanding about it or get some more training. The concepts I have, there's so many good things to share that I've taken from our 3-day course and just kind of give it, like I said, a sampler of the things that I want to share with you. One of the things that I want you to think about as we go through this is think about some of the conflicts that you know of or are in, and think in terms of some of these concepts and tools that I share. But I want to share with you the idea that as leaders, and there's places where you're going to be problem solving all the time. And when problems solve well, we don't think of them as complex, but they're really complex. We're trying to get something done. We're trying to figure something out. And when they go well, we don't often really even notice that we've used some skill and some ability to get through it. So there's a lot of things that people are doing already. The challenge is when does it break down? When does it get difficult? And when do we get stuck? And those are the things that lead to the conflict that people are either triggered by, take a lot of time and energy, and really can set people back and get people stuck. And so being able to think in terms of the places where you're problem solving and how these tools and concepts can be helpful is what I'm hoping to share today. But by no means have you be master them in an hour just from hearing me share them. One of the other things I want to have you think about is the concepts of problem solving and conflict resolution really are applicable everywhere. So it could be in your private life, it could be in your with counselors, it could be with administrative team, and or it could be other municipalities that you have to negotiate and work with, and all of those places tend to have problems to solve and conflict to solve. And so anytime we're having to deal with the interaction of power and autonomy of roles, like Judy was talking about, knowing the roles in the organization, and then also the roles of people outside of your organization that you might be interacting with. There's a certain amount of power and autonomy that goes with their role, and being able to recognize and understand that and navigate that is helpful. So those are the kind of things that I want to talk a little bit about. Conflict arises based off a number of things, but when it comes to municipalities, what I think about are things like and history. So the bad relationships that exist, or personalities that make it potentially a bad relationship. When things are good, no problem. When things are bad, suspicion arises. Approaches that people take might not be considered helpful, or could be frustrating to other parties, and that's where things start breaking down. We get involved in conflicts when they're often at a point where nobody knows what to do with them next, and that's okay. Our role as mediators is to come in and help loosen up that stuck spot that people are in and figure out what kind of other options they may have. We also love to help people in navigating those problems all the way through, and thinking about the opportunity to be able to problem solve and influence the people that they're working with in ways that are productive and respect that dual responsibilities of both parties. And so one of the things that I want to share today is this concept that when we're dealing with conversations or problem solving, there's a lot going on that is hard to mark or understand or even identify is going on. In any conversation or problem solving that we're having, there might be power, there might be people's interests, there's approaches people take, there's history that you may or may not know, there's the context, right? There's legislation. So all of these things are going on at the same time. We use different skills and process things as we're in these conversations. And so what I've got here is a picture of a conversation occurring, and beside it a broken or a pulling apart clock or watch. And the purpose of this is to share that most of conflicts aren't one size fits all. There's not one thing that's making everything fall apart, and it's not one thing that's going to fix it all. It's usually a number of things that are interacting with each other, and having a sense of those and fine-tuning those pieces can mean that you can be more effective in improving the influence you might have with somebody, or getting somewhere with a decision that needs to be made. And so being able to know what those pieces are and identifying them and being able to know how they operate can be very helpful, or getting someone that can help you identify those. The idea of conversations having all these parts and elements and dynamics going on may or may not be new to you, though we often can get stuck in conversations not knowing or paying attention to what's really going on. And realistically, I'm not sure if everyone else can relate to this, but there are all sorts of ways that our brain will take us in different directions when we hear or see or are reacting to things. And so often when we think about problem solving, we're thinking about how to stay engaged, both us to stay engaged with the topic and figuring out what the best way to solve it is, and staying engaged and trying to understand the perspective and what is going to help shift, or what other options we may have to problem solving the conflict that we're in. And so breaking this down is part of what I'm going to do today, is just give you a description of a bunch of these pieces. One of the important things is, I imagine if you think of a watch, it doesn't help a lot to tell the time, but a watch wouldn't be very effective if it didn't have a case, a backing to it, or a face to the watch. All these pieces would fall apart. And I really am glad that Judy talked a little bit about trust going in her presentation. And I want to just touch on that. Steve Covey, many people are familiar with Stephen Covey. He's works with a number of corporations and organizations about effectiveness, and has written books and has techniques that people are really familiar with. His son wrote a book called The Speed of Trust. And he has this quote when he talks about trust: "Low trust is the unseen cost in life and business because it creates hidden agendas, guarded communication, thereby slowing decision-making. A lack of trust stymies innovation and productivity. Trust, on the other hand, produces speed because it feeds collaboration, loyalty, and ultimately results." And so there are a number of ways to approach conflict, and when we think about one of the first things to think about is to think about building the relationships with folks that you're working with and having that trust. So it's the casing that all of your communications are going to be in. It's going to be the context. There's so many ways that communication can go wrong, problem solving can go wrong, and being able to have that rapport and that trust and familiarity, even if it's knowing where people's faults are, can be helpful in being able to navigate. And we'll talk a little bit later about assumptions and the difference between making sure that we truly know what might be going on for somebody, or what's their weaknesses or strengths, and also recognizing when we're making assumptions and how to check those. But that trust, even trusting that somebody is going to need a hand to solve something, is helpful. Getting to know people, having that relationship and the rapport means that we can have that speed that's talked about in this quote. And I think most people can relate with the fact that when you're apprehensive or unsure of something, you go cautiously into it. And so being able to have a rapport and a communication that's open to begin with, whether it's with your colleagues, whether it's with fellow council members, or potentially even ratepayers, having some trust with the community, having trust with these individuals makes that helpful. And so one of the tools I want to share with you is a tool that was brought together by two guys actually, named Joseph Luft and Harry Ingram. They came up with this idea of building trust and understanding people can be kind of broken down into these 4 windows, or 4 panes of a window. And it's talking about what we know about ourselves and what we know about don't know about ourselves, and what people know about us and what they don't know about us. And it can be very helpful in looking at a relationship that you're either developing or maybe struggling, and trying to figure out what you need to share, and or potentially what you may want to ask about, or what you may want to be able to raise an issue with. And how this works is, the first pane is that public field, and that's the context I was talking about. If I know a person well, I know kind of a little bit about their family life and their different likes and dislikes, some of their personality pieces. I get a good sense of who they are and what they're capable of doing. I know where things are coming from. If they say something, I'm more likely to interpret it the way that they intended, because I have a better sense of where it's coming from. And so that's that public field, what we know about people and what we know about ourselves. And there's lots of stuff that people don't know about us, or we don't know about other people. They might have not shared it with us. They might be intentional about keeping that quiet. And sometimes we're not thinking about what we're sharing or why we're sharing it, or why we're if it would be valuable to people. And I'll just use a very simple example. If I'm working with a bunch of colleagues and we are working on something together, and there's an expectation that I'll be there, and I'll be there happy and doing my job and fulfilling my role, but I've got a lot going on in my personal life. It may not be anybody's business to know what's going on in my personal life. However, it may affect our ability to work together, and I might want to determine what information I should share, right? I may want to let people know that something's going on, that there are some challenges that are going on, and be selective, obviously, about who I share that with. But opening that private veil, what people don't know about me, and kind of giving them that information, can help them know and understand, like, why is it that Scott looks exhausted? Why is it that Scott is a little more grumpy than he usually is? It gives some context to where things are at, and it might be immediate. It might be something long-term. It might be, did you know that 10 years ago this occurred to Scott, and it affects the work that he does, and his ability to do things. So that could be very valuable to share. And when we reflect on those relationships and think about what we think might be helpful, that's one of those places. The other window that's kind of interesting, or pane of glass on this, is the knowing what is known to others but not known to us. And those are the things that we don't even realize. They're called blind spots, the things that we do or other people do that they just might not be aware of. And so if we're working with somebody and there's something that they're doing, there's a good chance that if it's kind of annoying or it's getting in the way of the work that we're trying to do, it's not a bad place to start thinking that they may not know that. There's lots of stuff we don't know about ourselves. It's, we see things from our own perspective. I don't have a very good understanding of what the back of my head looks like, other than if I get a picture taken of it and someone shows me that. And that's the thinking when it comes to operating with other people, is what is it that I don't know about myself that I may need to be figuring out, whether it's the process I take or the things that I'm saying, how they're coming across. And maybe when I'm dealing with somebody, thinking about maybe I could raise an issue and let people know that maybe what they're doing is something they are unfamiliar with, and potentially sharing with them can be helpful. The last section is that spot where we don't know what we don't know. There's things that we don't know and other people don't know about us. We may not know until the circumstances arise. And that's just important to know that there are things that that people do under different circumstances that may change what their regular sort of mode of operation is. And so I hope that can be a little bit helpful. And what we're talking about is intentionally thinking about expanding public view in the relationships that we have, thinking about what can be helpful to create context for our discussions and for our planning with the people. And so that's a little bit about the rapport and trust and where we can start building that. Once we're in the situation, it's too late. It's hard to build trust in the middle of something, though there's things we can do to try to solve the problems that are getting in the way of trust in the moment. But it's one of those things that we need to build on an ongoing basis. And I'm surprised when I worked with a number of RMs and municipalities throughout the province, and sometimes I come back to their to work with that group on something different. And what's interesting is the commitment that I see sometimes when people say, at the end of a meeting, they've solved the problem and they realize, you know what, we need to be communicating more on a more regular basis. There's lots of times that people make those commitments. And usually when I get called back, one of the first things I ask is, you talked about communicating more, with whether it's a staff team meeting or whether it's between municipalities. How is that going? Well, we started, it was really good, but we haven't done it for a while. And usually that's part of the problem that may exist, is just not maintaining those relationships, having a rapport with people that can make the more difficult situations even more difficult to manage. So I just want to emphasize that that's a little bit of the casing of what communication skills and problem solving is in. Hope that makes sense. I'm going to shift gears now a little bit to talk about the next piece. Is a bit of a dynamic that occurs when people have power, when they're decision making, and when people feel whether they're feeling that they have power or they don't have power. And so if you're interested in looking into more of this, the creator of this concept is Steve Karpman. And what he did is just a simple triangle that says that when things can go wrong, sometimes the roles people take is one of these three roles. And I'll just speak briefly about each of these roles. So one is the victim, and that's the thought that somebody has a lack of power in the things that they need to do. I don't have the information. I don't have the ability. I don't have the cooperation, and I feel stuck because I'm lacking some of that power. And oftentimes, when somebody feels that they're stuck and they're lacking power, there's somebody that they're blaming. There's somebody that they're thinking is either not cooperating with them or holds the power. And in Steve Karpman's theory, he talks about it being a persecutor. And when you think about any conflict, you seldom hear somebody say, yeah, it was my fault. I'm the one. I came out. I have all the power, and I'm creating this problem on purpose. If that's the kind of person that you're dealing with, that's a really heightened situation that we're going to have to work through. But most often, when I talk to people, they will, no matter who I talk to, they're going to put themselves in that category of likely being the victim. They're the person that feels that there's something that's being misunderstood or not being able to gain the power that they need to make decisions. And oftentimes the person that's thought of as a persecutor by one sees that in reverse with the people that they're dealing with. So you'll often see, and that's why it makes sense that people have these camps that sometimes divide groups, whether it's sometimes the council or communities where it makes sense to some people, but it doesn't make sense to everybody. And it's because there's probably something going on both sides that needs to be understood and shared. And usually if people get stuck and they feel powerless, there's a tendency that Steve Cartman talks about of people looking for somebody that has power or something that will give them power to make the decision go in their favor. And that position is called the rescuer. So it might be somebody to make a decision for you. It might be legislation that you use to prove your point, to get across. And that's not a bad thing for creating understanding for your rationale. It's not very good for potentially persuading another person or party that you need to cooperate with, or they need to cooperate with you. There needs to be some influencing that occurs. And using power, having someone rescue you, or if the person that you're dealing with or party takes that first step and tries to get somebody to rescue them, it only heightens and you end up getting in a power struggle. And so trying to avoid this, Steve Cartman suggests shifting these roles. And just really quickly, I'll go back here for a second. When you think of the rescuer, you might find yourself in the role of a rescuer at times where other people are in conflict on council, or ratepayers might have concerns with the things and way things are being done, and you are might be administrator or somebody that's on a staff, and they're coming to you to hopefully get their problem solved. And if you take on that problem, number one, that may not be your role, as Judy was talking about earlier. You take on that role, it's great if you solve it. But if you don't solve it the way everybody likes it, you're probably going to create an enemy as well. And so the rescuer's dilemma is, if you get it right, great. If you get it wrong, or wrong in somebody's eyes, you still got problems, and they're gonna persist. And so there's definitely victims that have, we're not talking about being victimized by, crime or something along those lines, and that we shouldn't be rescuing folks that need assistance in those regards. We're talking about the communication and problem solving. But if we rescue, we can run the risk of doing a couple things. One is we just become the source of all the problem solving. People's capacity doesn't increase because they're not talking and solving the problem with themselves, between themselves. And then one of them, like I mentioned, is that they can turn on you. They can see you now as the persecutor, as taking sides with somebody, or making a decision that's not accurate. And that's, you really run that risk. Now, absolutely, sometimes you're the decision maker, and if it's appropriate based on your role and that sort of thing, it can be very helpful. What Stephen Cartman says, and what we would suggest, whoops, I went too far. What he would suggest is to shift those roles. If you find yourself in conflict with somebody, think about yourself as being a teacher and learner, and thinking about, what do I need to share with that person or party to better understand what's not working and what I need to assert. And learner is try to figure out and understand what's going on for that other party. And I'm going to give you some tips on later on how and what to look for to better understand what motivates people. But you know, shifting that, if I take that approach, I'm more likely going to influence the person that I'm dealing with. Active listening, paying attention to folks will often elicit from them cooperation in ways that that can be helpful, and then we can assert and influence them as well. And so if we can do that, great. We don't need to potentially have a facilitator or someone else help us, but sometimes we do, right? Or sometimes people will come to you still because they're stuck. And as they come to you, instead of rescuing them, the invitation to consider is, how can I facilitate this? And when is it best to facilitate? And it might be facilitating people's to the resources that can help them, right? So here's the act, here are the people that can help you problem solve this, or how can I help you with communicating and dealing with this this conversation or problem that you're stuck in, and helping them help themselves is a position where you're empowering them, and they're participating and potentially solving the problem and improving or maintaining the relationship, which means particularly in business and in government, you've got this ongoing relationship and responsibility that having a good relationship or building that relationship is really key. And so preserving it is, you can interject, make a bad decision or a good decision in our minds, and it can affect the relationship the next time we have to interact with them. And so in our longer training, we would go and show some scenarios of what that could really look like. But I just wanted to kind of give you the sense of you know, we're trying to balance power often when we're dealing with somebody that has potentially equal power to us, whether it's a council member or another RM or a municipality that we're dealing with. We probably need to figure out how to balance that power instead of fighting the power. And which leads me to my next slide, is the approach we take it can be broken down into looking at it in kind of along two axes. One is, you know, what kind of level of cooperation do I have in this problem solving with these folks in my life? And what level of assertion am I asserting, and do I need to assert? And so this approach graph shows that there's basically five different approaches that people can take in communicating, problem solving with others. And they're either high or low or balance of some of those level of assertion or level of cooperation. And oftentimes when someone comes to us and they tell us that they have a plan or a solution or a complaint, it comes across as competitive. It's that they're asserting their issue. They may not be interested in listening. They just want it solved. Or we might take that approach as well, and especially if someone's being very competitive or assertive or even aggressive to us, our likely reaction is to also meet that with a similar level of competitiveness. And what you end up having there is winners and losers, which isn't always great when it comes to a relationship that might be ongoing. And so being competitive has its pros and cons. And if that's your main approach, be very good at knowing where that works well and where it starts breaking down for you, or particularly breaking down that relationship when you may need it down the road. I think of police officers or anybody else that has an authority on a scene. It's very good that they take authority and act in their authority. The reality is, if they don't ever turn that off, they're gonna probably irritate a lot of people and cause some friction as well. Knowing when to use that authority and be very assertive without worrying about cooperation needs to be considered, wisely, and when to use it. Most people probably fall in this other category where they're not really asserting anything, or they're maybe not asserting or not cooperating either, and they're just avoiding conflict. And that means that it still exists and it's going to find its way somewhere. Avoiding conflict can have a really negative effect if that's the only thing we do, if it's our go-to all the time. It's sometimes good if someone's in our face and angry, to be able to avoid sort of responding to everything that they're saying, ignoring some of the things, planned ignoring about what they're doing, can help us stay engaged and stay calm and manage the situation well. But leaving things unaddressed is not likely going to be very effective in the long term, especially for us as leaders when our role is to address and deal with things. There's an accommodating approach, which is where people are really cooperative and they're saying yes to lots of things, but they're maybe not asserting what they need. And if that's the approach you take, where it's important to balance is knowing what your boundaries are. When is it appropriate to be cooperative, and when should you shift into making sure that your interests are heard and being addressed or balanced in the discussion. People can get resentful if they're constantly accommodating and it's not reciprocated. And then I'm not going to speak a lot about compromising just because of time, but collaboration, as you notice, it's in that far right corner. That corner is really saying that it's that perfect balance of being able to be cooperative, listening, participating, showing respect, and also at the same time being assertive and getting your points across in a way that doesn't wreck that cooperation. And being able to balance that out is collaboration. Problem solving with collaboration means that the solution will probably take into consideration both parties' interests, and is really important. But as an approach to even having a discussion, we greatly influence people when we recognize that our language can be cooperative language, collaborative language, where it's like my perspective, where what is important to me is, and I'd love to understand where you're coming from. But that kind of language doesn't give up power. What it does is it suspends judgment, and it keeps us engaged and figuring out what we all need to know to be able to make the decisions that we need to make, instead of making decisions rashly, or even worse, we're kind of responding to what's going on and reacting instead of responding to what's going on. And so as I've talked about this, you might be thinking to yourself, yeah, I think I'm in the avoiders club, or maybe I'm a very competitive person. Know that, number one, all 5 of these are good. There's no bad one. It's just if it's used inappropriately, that's where it becomes bad, or becomes frustrating to us and the people we might be working with. So know where you fit on there. What's your natural go-to, especially under stress? Are you going to say yes when you really should be holding ground, or say yes when you really should be saying, let me get back to you, or let me think about this? Or are you just really competitive and challenging people when you don't need to be challenging them? Not knowing how to manage that is usually where a lot of the personality stuff can become an issue, and people get offended by the approaches that are taken when they're not respectful, particularly when you're talking about balancing power, whether it's with colleagues and other municipalities. So I hope that gives some sense of looking at the way we communicate with each other. And if you think about a conflict you're in recently, you could probably ask yourself the question, what approach did I take? You might ask yourself, what approach did they take? Okay. And you might even ask yourself, if I was to ask that person what approach they thought I took, would they see it the same way, and why? Why would they, or maybe why would they not? And that can be very helpful to recognize that there's a separation sometimes between what our intent is and how it comes across, and being able to make sure that those things align when we're trying to use and balance power and be effective with other people. When people are aggressive, we can help them engage by being more cooperative. It's likely that people don't fight when there's not you're not engaging with them in the fight. Not to say that not everybody fits in that category. I'm sure some people you might think are an exception to that. But I know that I work with very high conflict people in other roles, other mediations that I'm in, not municipalities usually, but sometimes. And the reality is that every scenario can have some influence. We may not have power in it, but we can have influence. And it's one of those places where if we effectively sharpen the skill on that and the understanding of what we're doing in those moments, we can be really effective at influencing the direction that it goes. And so I want to share this concept here, is that, part of being effective leaders is being able to know ourselves. Where do we get triggered? Where do we disengage? What's the approach that we take? Am I considering, a lot of the factors that are going into the conflict or interaction that I'm having with somebody? The more we know ourselves and understand ourselves well and can be aware of, because there's an emotional side to us, whether we like it or not. People can trigger us by things that they say, do, whether it's a lack of respect or the tactics or approach they take. And our immediate effect on us may not even be conscious. It's just a quick reaction. And knowing ourselves and knowing what our buttons are, where we stop being effective, where we get distracted, where we get triggered, can be very helpful. So we can now say, okay, I have a choice now. I'm aware of what I'm doing. I'm not just reacting. That's really key. And then the next level is, if we're good at that, we probably have a good ability to, especially if we're listening and trying some of these things out, we're going to get a better idea of what's going on with the other person. What is it why are they taking the approach that they are? And the tendency when we're really frustrated is to oversimplify and just, demonize the people we're in conflict with. And there's good reason why we do that. I mean, it's self-preservation sometimes. But the reality is that, they probably think in their minds that what they're doing makes sense somehow. And being able to figure out why they're taking their approach and then adjusting our approach to see if it doesn't affect their approach can be very helpful. And often, even with the high conflict folks that I work with, that's exactly what I do. It's building rapport, try not to lose it by burning it off in challenging when it doesn't make sense, but being very straightforward when I need to be. And so often that can gain respect and help create a more equal conversation. Just like Judy said in her presentation, having difference of opinion is not a bad thing. In fact, it can be helpful in creating good wisdom and good decisions. It's how we do it that's usually the issue, and that's where people get into trouble. And which leads me to my next slide. When people approach things, this is going back to thinking about the conversations that we have. We often don't label what we're doing. We just have a conversation the way it naturally occurs. Naturally sometimes is not the best option. Naturally means that we might be doing it the lazy way. We might be doing it the reactionary way. It's not always the best way. Being intentional and making intentional moves is really important to be, particularly as leaders. And so being able to identify when someone's talking to us, or when we're even trying to assert something, being cautious and recognize the difference between what's called a position and our interests. And what I mean by that is, our position is the reason we do, or what we want to have happen. And it's usually pretty narrow. It's typically can only be satisfied in one way, and that's to do it that way. And it usually, if someone doesn't agree with it, it now becomes a competition. It becomes a win or lose. And often when we speak in terms of this must be done this way, or this is the way we're going to do something, and it hasn't considered potentially other people's interests, they may be resistant, and then we're in a pickle because we've already committed to a position. And so when we're proactively working with somebody, or even if we're stuck, what I would always suggest to people is think in terms of communicating from the underlying motives that are needed, that are they're called interests, which are the needs or hopes or wants that people have. And I'm talking about that in terms of what's needed, what's important for this to be able to work out, and how do I communicate that with the people that I'm working with. And so if I can say what I want in a process is fairness, most people would agree with that. If I can say that it needs to be fiscally responsible, right? That's a good interest. That's why I might make a decision. Nobody's going to argue with that. But when I say, well, we're going to cut this, and someone else is like, wait a second, how do we get to that position? They will take maybe an opposite position, and we get into this competition instead of problem solving. And so understanding interests, that people have these underlying motives, we do as well, and the people that we're dealing with, trying to better understand what that looks like will help us in being able to speak to that instead of trying to just debate the positions that we're in, because then it's just a winner or a loser, and it's not a good situation when, yeah, I win, that's good, I get my way, but then I got to meet and counsel again with that person, or I have to work with that person on a committee or that sort of thing, or now we've got to request something from the other RM, and now we're in a stuck spot with this bad relationship. So one of the things the Ombudsman uses this as well, it calls it the fairness triangle, but it's this idea that there's 3 elements to making something work for people, and it's not just the decision, it's how it's made and the impact that it has, or the message it sends in the way it's been made, or the decision that's been made and what it says to people. So it's that substantive, procedural, or psychological. And I'm thinking in terms of making a decision. There's a mediation that I was involved in, and this isn't RM related, but it could happen in any RM. There was a business person who's building in an RM, I think, and they were building a business. They needed to put a bunch of electrical in it, and the bill was an $80,000 bill. When he first started building this new business, he was working with the father of this electrical company. He had a good relationship with the guy. He trusted him. He knew he was a hard worker, good work ethic. Then he needed to work on another job, and I think it was his son ended up being the person that he was now dealing with. And this business owner started having some suspicious concerns. Things weren't being met. Part of it was about his approach. And when he asked or gave him the bill, he had a few questions. He didn't trust this guy as much as he trusted the other guy. So again, rapport makes a difference. Because he wasn't meeting those needs and didn't have the same relationship, he asked them some questions. This person, this electrician, became offended by the fact that he was being challenged on what he was doing. I'm not sure if he was doing something wrong or not, but became offended. And so instead of continuing to negotiate, he just started an action through the Court of Queen's Bench at the time. And so they got into this mediation, because mediation is a step in litigation, or down the litigation path. And they got together, they started talking, and they weren't talking very nicely with each other for the most part. And so they got to a point where he knew that he had to pay this bill. He just didn't know if he trusted the amount. And so he's trying to get some information. This guy wasn't being very good. And so they kind of knocked it down. And really, they knew that going on to court would just kind of chew up a bunch of their money, and not sure exactly how it would turn out. And so they wanted to try to get that solved that day. We took a break, and I met with one party, and they had closed the gap. The $80,000 bill is now somewhere in the $60,000 or $70,000 range. The one guy was willing to accept a bit, but there was a gap of $3,000 or $5,000, and it really wasn't a lot substantively, But when I met with the owner of the business, he said to me, Scott, what he doesn't realize is if he would have just answered my questions or shown some respect and understood that I just had some questions, I probably would have paid the entire bill. So they're now splitting a difference of a $3,000 gap that's lower than the original amount. And it was based off the fact that this relationship broke down. He didn't like the process. He was being disrespectful to each other. And he knew that he needed to pay the amount. And he said he could close that. He totally would do it. He would probably pay him the whole thing if this guy just was acted differently to him. And so know that when you're interacting with people, you can take a guess at what might be some of those underlying motives, but know that it's not just about the solution at the end of the day. The substantive can shrink or grow depending on how effective we are procedurally or psychologically. What's the messaging we're sending to people? If we're being disrespectful, or they may easily make it more difficult for us when we're trying to work with them. And so just know that those are some of the things that are going on for people. Now I'm getting very close to the end of my time and don't have a few more slides. So I want to share this with you too. Bad behavior, especially if that's part of the issue, is hard to tell whether it's just really intentional bad behavior or if there's something else going on. And so I want to share this concept too, is that there might be 4 reasons why people do what they do. One is that they may not be aware of what they're doing and they're not aware of the impact. So back to that blind spot that we were talking about earlier, people might just not realize that they're doing something. Like it could be a blind spot, and then they certainly aren't aware of the impact it's having on people. Sometimes they're aware of, number 2, they're aware of the action. They know what they're doing. They're just not sure of the impact that it's having on somebody. It's something that they didn't consider would be a problem for somebody. It's not a problem for me, probably not a problem for others. And sometimes behaviors are really that simple. And really those first 2, giving and sharing information, can oftentimes just resolve it. And I've been in RMs where there's been some issues where they started talking and sharing information, and they like, oh wow, I didn't realize it came off that way. That's not what we intended. And boom, now we're cooking with fire. People are shifting really quickly. Number 3 is a little more tough. This is where people know what they're doing, they know the impact, but they're justifying it for some reason. Okay, and we might justify, or they might be justifying. And how that works is that it might be what we're used to. Like, this is how it's usually done, right? Culturally, right? That's the way it gets done. But if it's not working for somebody and they're struggling, then there's an issue there and it needs to be resolved, not avoided. But sometimes we make decisions because it makes sense to us based off of what we're used to and the way we see things. Sometimes it's about reciprocity, and particularly in small government or municipal governments, is you've got these relationships where the last time we were in negotiations, it went this way. And so now it's reciprocity. I know what I'm doing. I know the impact that it's going to have. It's just, they were a jerk last time. So this time, I'm going to be the jerk. And realistically, some of the things that we're talking about today can help us get out of that spot and then figure out how to move forward in a more productive way. We're not stuck just because of reciprocity and that people are doing things intentionally. They might be doing that. We just need to figure out potentially what interests and other options people have. That point C under number 3 is my needs are more important. And sometimes people think that too, right? Well, we need to expand the town. We need to, get this road clear, or we need to have access to this road. And all of those decisions, it seems like it's important in the moment to one or both of the parties. And so people, they know what they're doing. They just think that they're more important. And knowing that might be the case, we can still influence each other and still negotiate and be able to come to a conclusion that works for both of us, or at least accepted by both parties. And which is always better than having someone else have to interject if we can solve it ourselves. The last one, though, number 4, I just want to let you know there are some people that are just jerks. They're bullies. They know what they're doing. They don't care. They actually do it on purpose, not because of reciprocity, but they're really doing it to stir the pot or to overstep their boundaries. And just know that all 4 categories can look very much the same. And lots of times the folks we're working with just don't fall into that last category, but there are people that do. And how do you know the difference, right? And some of these tools we're talking about can help sort through that and get a better sense of what we're doing. So I'm going to take, if it's okay, just a couple minutes into our question and answer here, just to end off with these last 2 slides. When I think about how easy it is to make mistakes, this is and where assumptions play into things. Number 1, we always make assumptions. We don't always have the full information, yet we make judgments based off what we do know. That's called an assumption. It's okay. We all make them, and a lot of times we make good assumptions. We assume the best. Just know that any assumption that we're forming with a lack of information is an assumption. It's not fact. It's not knowledge. It's not for sure. Very well could be, but we just don't know for sure. And that suspending of assuredness means that we'll ask questions and we'll stay cooperative until we do know. And it can help us through those first 3 categories instead of just assuming that we can't get places. And how that works is that there is, I'm just going to use this handy dandy thing here. So there's an action, whether it's things that people say or do, that happens publicly. People see it and hear it. But we don't know why people do it, their intentions. They might have a purpose that they think they're meeting, and they may not know this, like I said earlier, the impact. And so they might have an intention that's good, but the action does not get received the way that people expected. Oh, I thought I was informing them that we were going to want an annex, or we were going to do these things. Well, that might be all well and good, but the impact is the impact. And a lot of times we make these assumptions about people's impact or how they're going to take something or what their intentions are. And we start speaking from that as if it should be and could be or must be. And that's where sometimes we make, we start laying a foundation and then trying to build on it that isn't really firm. And so we want to make sure that we get a better sense of things, and a good conversation, raising issues, having somebody help us facilitate through those discussions can help us get the impact out into the public and the intent into the public discussion, and then get clarity on what it was meant to happen and what we need to now do going forward. Just know that one of the things that complicates it is that I've got this as 2 lines here, and if you can see, it says personal history and other things like how you're feeling that day. What happens and how we see it or hear it has a lot to do with the relationship we have with people, what we think about them, the words they use, the approach they take, and we start making assumptions very quickly, and that can be like a colored lens when it comes to interpreting what people are doing. And we want to recognize we could be right, but it's both respectful to and also more effective if we just ask the question or have the conversation in a way that's respectful as well. And so there's lots of ways to get into trouble by making assumptions. And I've got some great stories if you ever want to hear about them, about where people can make some assumptions that get them really stuck. And they're good assumptions, like based off of what the information they did have, that does make sense, but that's just not what's going on, or the way it was received. And so, and I love this quote: "The single biggest problem with communication is the illusion that it's taken place." We often think we're hearing things, and sometimes it's not really what's going on. And so when we are trying to raise an issue or get some information, there's these 3 points that I would share that can be very helpful. When you're stating something, talk about that what you saw and heard in the public side without judgment. Just, when you said this quote, there's no argument there. You're just stating facts. If you say when you dismissed me the other day in this conversation, that's got judgment in it. It already is going to provoke people and get their brains going in different directions instead of staying engaged. But when you can say that part clearly, and then talk about the second stage here, is the impact that it's had. So when you said that, I understood it to be because blah blah blah. You're filling in the gap. You're giving information. They're not likely going to argue with that because you're not blaming them at this stage. You're just sharing the information, how it came across, the impact it had on you. You're not talking about their intentions, because we don't really know what their intentions are. And people are going to get, a good way to start a fight is talk about someone else's intentions. You say, as if for sure. Even if you're right, they're going to deny. People can deny it and fight for that. But if you state the fact that this is what occurred, this is the impact it's having the way I see it, and I'd just like to have a conversation with you about this, that invitation opens up the ability to start off collaboratively and have a conversation that can be helpful. Anyways, I think that I've got two more slides. One's a cute little video, but it's not it's not necessary. It's just something to share at the end here. But thinking in terms of that what, so what, now what approach is a really sweet way to be able to be assertive. You're getting information across, but you're not being aggressive, not creating a fight right off the bat. So you're dealing with things and moving it forward. That last slide, I'll just share why the video is that if you think about your relationships, whether it's in a community with colleagues or other municipalities, think about it as a three-legged race. Everyone's seen a three-legged race. Everyone's seen them go bad. This video is a cute little thing where it shows these kids trying to get across the line, but they just keep falling. And what I would ask is, in a three-legged race, when someone spills, whose fault is it? And it's almost impossible to quite blame whose fault it is, because there's contributing factors. And some of the things that we're saying is that as a savvy leader, you can have insight into these sorts of things, that you can influence the impact in a positive way, or you can potentially contribute in ways that are negative. Being open to hearing what people say are the negative pieces that you might be missing will influence them to more likely hear you if you've heard them out, which means that you guys will probably find a solution to it. If you don't, here's my phone number. And I just want to tell you that our office is always willing, and it's not my personal, it's our phone number for the office. And it can give us, we can help you coach through the conflict part of things, or potentially if there's a need to mediate a conflict that's really stuck, it might be helpful to go that route too. Sorry, I went a little bit over there, Dustin, but.
Oh, no apologies necessary at all. That was all really helpful and engaging stuff for sure. Boy, yeah, lots of wisdom there for us and lots of things for us to think through. Certainly, as you were talking, I'm like, oh yeah, that reminds me of a situation where I found myself in such and such a specific role that I was playing, or having assumptions or whichever. So certainly a very relatable set of things that you've discussed here. Welcome folks to put questions in the chat, and we'll get those transferred over to the Q&A feature. I'll be happy to read those out and invite Scott's commentary on them. Again, just want to remind folks that the chat is public, so whatever you post in there will get viewed by others as well. Maybe while folks are formulating their questions, I get to take advantage of the time that we've got here with you, Scott. I was thinking a little bit about some of the things you said, and curious about what are for our new elected officials, what are some of the most common points of conflict that you've seen that elected officials have to deal with? Are there some themes you've come across in your career?
there's most often where I'm getting involved is conflicts between the council and staff, or council with another council somewhere else. And it's oftentimes it's a little bit about the structure and the role that Judy was talking about, but it's also the way that it's approached. So you've got two powers, right? An administrator or staff, and then council. And council and or administrators thinking that they're crossing the line on whose role it is to do things. And sometimes that can be, there's dual sides to that role. And so there may be some place where you're kind of tethered together in that three-legged race. And it's how they have the conversation, whether they assume too quickly that I have the power versus you have the power, and not trying to figure out the respectful way to kind of understand the dynamics of what's going on.
That's interesting. I was surprised that you didn't say that there's a lot of conflict between ratepayers and elected officials. That's not a typical point of conflict?
That is, it is. We get phone calls on from administrators particularly, because they're usually the ones that are first getting it. But I'm assuming elected officials are going to get it from neighbors or business folks that are in the community. And we don't usually hear about it until it's too late, or it may become part of something. But these concepts and skills can make it very easy to influence and manage the problem that needs to be solved by ratepayers as well. And helps by, oftentimes they want to get their point across to be heard. And sometimes it's the competitive approach is, instead of trying to work with it, it's just a matter of dismissing it or championing it sometimes, which can become a problem if it's not, it shouldn't have been championed.
Yeah. That's helpful. Folks on the call here, just want to ensure that you do have opportunity to put in any questions you may have. Perhaps some of the kinds of questions you'd like to ask are the kinds of things you wouldn't want to put in a chat, which I definitely understand. Scott, I was curious, when I was listening to your presentation, you got to the part about bullies. And I know one of the tendencies I sometimes have is to go to that right away. Oh, that person's just a jerk, and I know that there are still folks like that out in the world. Before we go to labeling somebody a bully or a jerk, what are some questions that maybe we should ask ourselves first?
Right. So the interest part, that triangle with the procedural, substantive, and psychological, is one of the first places to go, is to kind of question what's going on behind that bit, right? And is there something that they're trying to problem solve and they're just not skillful at doing it? And that doesn't make their behavior right, for sure. I'm not excusing that. But as leaders, we have an ability to influence that, right? And to say, while we're in the middle of it, we can direct this or have some influence. So I think asking that is really key. Asking those for what category could this be in? Is it that they don't know of the impact, and how would I know for sure? If I can stay curious, I'm more likely to interact and share and get information. I might need to set boundaries about how we're going to have this conversation, but it opens it up for a discussion, and I suspend the idea that I can, and I say suspend because they still might be a bully. They might just be that, but we have a tendency to oversimplify, so then we can dismiss, right? People just can't work with a guy like Scott. Like, he's one of those guys. My experience is that the more skillful we get and the more experience we get, those folks that we used to have difficulty with aren't so difficult anymore. They're still pains, right? They might be issues. They're not our favorite people, but I can still problem solve with them as I get more skilled at it. And so my challenge is to not do that quick dismiss. It's to stay curious and then use some of these tools to consider, what do I need to share? What do I need to understand? And do I need assistance in doing that because of what's going on? Is a third party helpful, or can I do this on my own? Or even with some coaching, I could do it. Yeah.
I can see where some third-party involvement would be really helpful at times. It's hard to ask oneself those questions in the midst of a really difficult conflict. So I can see where your support and the support of your team members would be really welcome in those kind of contexts.
Yeah, and I want to say something to the folks that are thinking about when to involve somebody that, you know, like with our skill set is, sometimes folks think, well, if we bring somebody in, it means that we can't do it ourselves, and that's not the case. Sometimes conflict is between two parties and it's become competitive, so that they're not sharing information. The beauty of having a mediator or facilitator is that I get to talk to both sides, and I get to get a sense of how they're both seeing it and ways that I can communicate it and help get unstuck. And so it's the third person, particularly neutral, that doesn't have a say in the outcome, is more likely to have changes the dynamic of what's going on there.
Right. I did see a question pop up in the chat here. This one reads, hi there, how do you deal with counselors into your purse when into a closed session? So I'm not 100% sure what they mean there. Maybe they were trying to get at a situation in which with a counselor getting involved in a closed session when maybe they shouldn't be. I'm not sure. Maybe Charlotte, if you want to try rephrasing your question, that might help us to get to it a little bit better. In the meantime,
what if I can just even take a guess at
Yeah.
what that might be is whatever the situation is, I think one of the main answers to a lot of the questions is to raise the issue and figure out how to assert what it is that you're trying to get across, but not in an aggressive way, but in a problem-solving way. So if somebody's getting into your purse or personal life, I'm not sure what the question was, whatever the behavior is, it's if I come out saying what you're doing is wrong, you're gonna trigger somebody. They're gonna go get defensive, and they may not even know what you're fully talking about. And you can talk about something in terms of, I hope not your actual purse. Yeah, I like that comment. But what it does is it's what I can say is from what your behavior, whatever you did, I'm not even going to say if it's right or wrong. All I'm going to say is it's not working for me. And if it's not working for me, or I don't find it appropriate, then you and I have something to work out here. And it's way better to take that approach than to say what you're doing is wrong, stop doing it. And you might be totally right, but you're not influencing. You might just be starting a conflict, a competitive, spar. Whereas if you say what you did, regardless of whether it's right or wrong, is not working, we need to chat. And I think we need to. That's your first step. And if it doesn't resolve there, and then you can move on to using other methods. But trying to resolve it at that first level is key.
All right. Looks like you got that exactly as she needed it there. So that's great, Charlotte. I hope that helps you out. Scott, one more question from me, and of course, other folks, please do jump in. Put your questions in the chat. Any advice for how to bring the tension or how to de-escalate a conversation if things start out bad? Do you have any get out of jail free cards here that we could help to fix something if it gets off to a bad start?
A couple things. So this might be boring to some folks, but they're finding out about how our brains work with the CAT scans and neurology things that they're doing. One of the things they're finding is that our brains have a tendency to problem solve or just react. And it depends on if we think there's a threat. And it could be a physical threat or emotional threat or intellectual threat. If we feel challenged by somebody, it likely can create a response. Reaction. And if we're reacting, we're less likely being intentional about what's going to happen. And so part of what I was hoping today is to share different concepts that could just get us to think and suspend that judgment for a minute. Because as soon as you catch yourself and think, why am I reacting this way? What is it that I'm assuming is going on here? All of those things create doubt in me being so sure that I'm right and that I have to put an end to this. And I'm not saying we're not and that we need to pussyfoot around things, but it might be just saying, I'm going to give the some reasonable or a respectful interpretation on this, that maybe it's not as bad as I think it is as a start off. And then by saying and having that perspective, I'm going to choose to be able to be more skillful in my next move, right? Instead of just being reactionary. The reactionary thing will escalate. I do this, they'll get angry, and then because of what it is it's usually a power. There is salt in my power, so I'm going to gain power, which is usually over top of the other person, which means that they'll keep escalating. What I need to do is realize I don't want to go that direction and either meet that person there or just de-escalate it by calming myself and then inviting someone else to do the same, and then choosing to do a process that works.
Really helpful.
Sounds easy, I know, but it's
yeah. Yeah. There's another good question that came in here recently. Can you explain the difference between conflict and harassment?
Ooh, that's good. Harassment, it's kind of like those four things of bullying. Bullying and harassment can be a word that people use too quickly. And I'm not saying that the behavior is not inappropriate, but sometimes it's not always harassment. So it could be bad behavior, it could be needing to be addressed, but it may not be harassment. Harassment usually is defined in law and when no legislations or bylaws. The problem even with that is that it can be subjective. And so people argue the point of whether it's harassment or not. And that's why in using people that can interject or processes that can be helpful to manage behaviors that are unwanted or are not helpful. And like I said, whether it's the way the smell of your lunch that you brought, or if it's the unwanted comments or jokes, anywhere along that spectrum, there's lots of gray zone that just really needs to be addressed. And so I'm not sure that I'm answering that question about defining the two, but a conflict is almost anything where it's not working, right? If we're not in sync, we're in conflict. It might be a very minor conflict, but it's a conflict. So harassment is probably a type of conflict, maybe, is what I would say. And it's a codable conduct by law, and certainly can be managed with a lot of the same skill set and or processes, whether it's mediation or it could be a harassment claim, right? The challenge is when we formalize things too quickly, that can also add to the problem. So we want to make sure that we get some good thought and counsel and in the sort of the steps you take when you're dealing with any kind of harassment. But even that can be facilitated.
Great. Really appreciate that. I saw another comment there come in. I think, though, I wonder if we should continue on, and looks like maybe there might need to be a little bit more conversation on an individual basis, though. So maybe I'll pause this part of our workshop here, and I'll thank you, Scott, again for your time and for your expertise and wisdom. And we'll aim to try to answer some questions offline, those that have come up. Maybe again, just for the folks that are listening here, if they wanted to reach out to you or your office to ask a specific question, what would be the best way to do that? I know you had given a phone number in your presentation. Is there one that you could share with us again?
Yeah, so 787, what was it again? 5747 is the main line. And I can give you my direct line is 787-8714. Particularly if it's a question that comes up out of this discussion, then definitely just call me and we'll chat about sort of the concepts and maybe more specifically what's going on for folks if they have any questions.
That's great.
Love it. Thank you for the opportunity.
Yeah, Scott, great to have you here again. Thanks for sharing your expertise, and I'm appreciative of the work that you're doing among our rural municipalities. So,
yeah, you bet.
Thank you. And Brenda, when you have a moment, would you mind turning your camera on and we'll transition over to your presentation. And there's Brenda now. Hi, Brenda.
Hi, I listened to the last bit of that and boy, that sounded interesting. I should have listened to the whole thing.
Brenda, welcome here. And Brenda, of course, I'll tell you a little bit about her. She's the manager of the Procurement Knowledge Center with the Ministry of SaskBuilds and Procurement. Brenda has 33 years in the public service, the last 6 working in procurement. She's worked with suppliers and procurement colleagues and currently facilitates procurement education sessions and provides courses on procurement best practices and trade agreement procurement. Now, Brenda, I've had the privilege of sitting in on some of your sessions that you've done, some webinars on public sector procurement, and I've always found them really helpful. The reason that we've approached you and invited you to present to this group today is because we just know that spending public dollars is a big part of what it means to be on council and making decisions around that topic. So you're able to share with us some really important information about, what sort of obligations public elected officials have, and maybe some best practices as well. So I'll pass over to you, Brenda. Welcome here, and thank you for your time today.
Thank you very much. I hope you all will enjoy this session today. We've got a little bit of fun activities planned, so hopefully you can be engaged with that. And let's get going. So who we are. My name is Brenda Maximuik, and Ms. Dustin provided that intro. Thank you very much. I work in the Procurement Management Division at the Ministry of SaskBuilds and Procurement. Our division is responsible for executive government, ministry, procurements over trade thresholds. And this includes managing the procurement process, developing the tools and resources to support both procurement education and training of our clients and stakeholders, and we support the implementation of best value procurement. So in my presentation today, the goal is to provide each of you with a strong understanding of what procurement is. It includes general steps of the process, important considerations, and where to find additional information and resources. I would like to leave you with a good understanding of the trade agreements and specific obligations that apply to municipalities. I will have time for some questions and answers, and it is a full agenda, so let's get going. So what is procurement? Self-explanatory, the process of finding and agreeing to terms, acquiring goods, services, works from external sources through a tendering or competitive bidding process. When a governing body, such as yourself, a municipality, acquires a good through this practice, it is referred to public procurement. There are 7 steps in the public procurement process, and they are needs identification, problem definition, decide on the approach, conduct competition, evaluate the bids, make an award, manage the contract, and then debrief suppliers. So with needs identification, the first step is to understand the need and the desired outcome. It can be accomplished through the development of a scope of work, and the more time you spend at this phase of the procurement, the better the outcome will be. This step involves developing a scope of work, which is a thoughtful process to determine what, who, where, and when aspects of the procurement. It involves asking and understanding what is the objective, what does the municipality and successful supplier need to deliver, what is the budget, should this budget be disclosed, what reporting or communication do we want from the supplier to satisfy your need or obligation, what are our responsibilities. This could include legislation, regulations, or grant obligations. What risk may arise and how can we mitigate them? Is there a perceived or real conflict of interest by anyone involved in the procurement? And we will talk about that in a moment. And any other important considerations. I can't control my slide here. Not sure why.
Brenda, you may just have to take control up at the top there.
Oh. Yes, thank you very much. So needs identification. If you are procuring goods, services, or construction that is part of a grant program, like the Investing in Canada Infrastructure Program, or ICIP, or the Canada Community Building Fund, formerly the Gas Tax Program, be sure to review specific grant program requirement for the procurement. These requirements are outlined in your funding agreement, and specifically be aware of any required threshold for posting, limitations on timing of the procurement award, and other potential claim eligibility conflict. So conflict of interest in the context of a public procurement. Conflict of interest in the context of procurement comes up frequently in news headlines, and it's something that elected officials and procurement specialists and buyers should be aware of and can identify and address early in the process. A real or perceived conflict of interest can arise in procurement when a participating vendor has an unfair advantage or engages in conduct, directly or indirectly, that may give an unfair advantage. It includes sharing information on the procurement that is not available to other vendors, communicating with any person to influence the procurement competition. This includes trying to influence the scoring of a procurement, evaluators, or lobbying the decision makers on how a procurement should be awarded, and engaging in conduct that compromises or should be seen as compromising the integrity of the competition. This includes personally benefiting from the procurement award, whether it's reputationally or monetarily. A recent example of this is an investigation into the Federal Ethics Commissioner requested regarding the International Trade Minister Mary Naig over contract given to a company co-founded by a liberal strategist. While the resulting contract was worth only about $17,000, the opposition party said the deal raised questions about whether any conflict of interest rules were breached because Amanda Alvaro, one of the firm's co-founders, is allegedly a friend. If a conflict of interest, whether real or perceived, is identified, it needs to be dealt with. The party with the potential conflict of interest should recuse themselves from the procurement and the award process. By not addressing a potential conflict of interest, it leaves your organization up to legal risk, and it undermines the confidence of the public procurement process. Vendor engagement. Vendor engagement is the process of collaborating between a procuring entity and existing and potential future vendors. Collaboration can be both a benefit to the entity and the organization and the supplier community. Vendor engagement provides the opportunity to explore, learn, and ask questions, foster innovation, encourage feedback, gain an insight into the capacity and capabilities, business community, and allows you to learn more about how best to scope, schedule, cost your projects, and structure your procurement. In short, vendor engagement develops relationships and establishes the groundwork for future relationship building with your supplier community. And vendor engagement can occur in a variety of ways, including industry sessions, whether it's person, online webinars, meet and provide procurement information to the industry associations, to distribute to members for feedback, one-on-one meetings for potential respondents prior to issuing the competition, engaging with all known respondents will demonstrate a commitment to promote the development of suppliers and enhancing your supplier and association relationship. Advertising a request for information or expression of interest on sastenders.ca. Once the request for information or expression of interest has closed, additional vendor engagement may take place. Pre-solicitation or pre-proposal conferences are another way to engage vendor approach. The procurement strategy approach. There's several approaches to structuring a procurement competition. The structure selected as listed should support the required need and outcome that you identified in step 1. For example, has an ongoing need for a request for supplier qualification may be selected. So if you have an ongoing need, that is something that you can use as an approach and strategy for future competition. An advanced contract award notice. Before we move from this step of the procurement process, I want to speak directly to advanced contract award notice, or ACANs. This is an approach that we frequently get asked questions. An ACAN is a formal notification advising suppliers of an entity's intention to award a contract to a selected supplier without a competition. They are not intended to be utilized as an alternative to the competitive process, nor are they to be used when there is insufficient time to run the competition. The ACAN process is only to be used when there is a strong evidence that only one supplier is capable of performing the requirement. The ACAN file should fully document all information regarding the process, as all materials in the possession of the government or in the municipality are subject to access provisions. ACANs should be used only if the above criteria is met, and using an ACAN to avoid the competitive process is subject to challenge and could result in needing to complete a full competition process, and there are legal risks. Standing offers are created to facilitate the procurement of goods and services used on a recurring basis. Sorry, just goods, not services. Under a standing offer, a supplier agrees to provide items in accordance with the terms and conditions outlined in the agreement. And in many cases, it is predetermined price or discount off the price. The benefit of a standing offer is that it is the competitive process has been completed. Government of Saskatchewan standing offers are set up to allow the MASH sector to access. It's a list of commodities available on the standing offer link above, and it's available on SAS tenders, and it will include items such as fuel, lights, PPE, and moving services. Group purchasing organizations, or GPOs, is another option that municipalities may be able to access. In a GPO, they leverage the collective buying powers of its members to secure discounted prices from suppliers and retailers. Examples of GPOs include Kinetics GPO, which has municipal members, and our health partners are frequent users of GPOs for drugs and medical supplies. GPOs are aligned with trade agreements in that they use open competitive procurement processes to establish a resulting agreement. Prior to utilizing a GPO, consideration should be given to the approved supplier resulting from the group purchase. The procurements may be large and or cover a large geographical region, which may deter small or local suppliers from participating. Local knowledge may not be considered in the evaluation of suppliers, given the regions included. Resources for competition documents can be found at the 2 following links. There's templates and guides available for the competitions, and you can go ahead and feel free to download or use them and accommodate them to your specific procurement. The procurement approach and strategy, something else you may want to consider, are site visits. Would suppliers benefit from seeing the project site or hearing from the manager or engineer directly? What is a mandatory requirement? And as stated, less mandatory requirements, the better they often, as many large competitions or any competitions that have a lot of mandatory requirements will limit the amount of suppliers you get bidding. An example of this would be doing a procurement for a specific brand, make, or model, rather than the needed outcome or the good. And it could be as simple as you need a Bobcat brand versus a skid steer. You need to have flexibility. And what does that flexibility look like? It is a one-time purchase or something that you need more than once. How will you evaluate your suppliers? The evaluation criteria should be established prior to posting and shared in the competition. Some examples of criteria to evaluate suppliers include your project methodology and approach, your resource qualification, the experience, and the local knowledge, warranty, timeframe, price, and whether supplier presentation will be needed. Now we're going to undertake the procurement. You're going to post the competition on SaskTenders.ca. Posting times vary according to what's outlined in trade agreements. They're going to address supplier questions, ensure resources are available to provide answers. So there usually is one point of contact recommended. Ensure information is provided to all interested parties. The supplier can request to extend the closing date. And if that should happen, that closing date can be extended. All suppliers get that benefit. Evaluation. The evaluation criteria document should be completed before responses are reviewed. Late proposals are not accepted. Only the content of the individual proposal is evaluated. You cannot score what is not there. Evaluation criteria outlined needs to be followed. Then you're going to make the award. Agreement documents can range from contracts, master service agreements, supply arrangements, and other. In the Canadian Free Trade Agreement, these transparency rules are outlined in Articles 516 and 517. To begin with, there is a requirement that the procuring entity inform all tender bidders or suppliers of the contract award decision in writing. If an unsuccessful supplier has a question with respect to the tender decision, the procuring entity is required to, upon request, explain to the supplier the reasons for the decision to not select the supplier's tendered bid. Contract management. You want to ensure that the deliverables timelines are included in the contract. You want to consider vendor performance and reporting needs. Supplier debriefs. A debrief provides participating suppliers with an overview of the strengths and areas of improvement of their response in each rated area. Supplier debriefs should be offered to all suppliers within the competition if they ask. If your municipality follows the 7 steps that we just chatted about, your procurement should align with the guiding principles that are indicated in this slide. They should be open, transparent, fair, flexible, consistency, clarity, best value for money with a focus on outcome and business solution, demonstrate respect for suppliers, easy access, innovation, respecting trade obligations, continually improving how to do business. So now here we're at a little checkpoint, and that concludes the main topic of the presentation. Before we move on to Q&As, let's have a quick check to test our knowledge on procurement and trade. And I have prepared a few multiple choice questions for you. Feel free to answer on your own or put your answer in the team's chat. First one, what steps in the procurement process should you engage with in suppliers? A, B, or C? The answer to that is that it's a trick question. Not sure what happened here with my slide. This was a trick question. Step 1 and 2. You want to engage with your suppliers on an upcoming procurement to collect feedback in support of defining requirements and determining the appropriate procurement approach. Step 3. While the competition is posted, supplier interaction should be limited to responding to questions. Step 4, no supplier interaction unless it's part of the evaluation process, example, a demonstration. Steps 5 and 6 is where you award and contract negotiations with a successful supplier, a notification of award. 7 is you meet with suppliers to perform debriefs. Question 2. Understanding using a tender is always the best choice when it comes to getting the procurement outcome you need. Is it true or false? The answer is false. There are several different procurement approaches that can be taken depending upon the desired outcome. Question 3. We are very happy with our current road maintenance contractor. When the contract expires, we can use an ACAN to ensure we continue working with that contractor. Is that true or false? The answer to that is false. An ACAN should only be considered for use when there's a strong evidence that only one supplier is capable of performing the requirement. It should not be used to avoid a competitive procurement process. Question 4. You've been asked to help evaluate a procurement on an engineering services project for your RM. One of the companies that is anticipated to bid employs my son. Do I need to recuse myself? The answer to that is maybe. Conflict of interest can be actual or perceived. Best practice would be to inform the RM that if the company that employs your son bids on the competition and is being evaluated, then a replacement for the evaluation should be sought. Trade agreements. Let's shift gears to the second part of the presentation and talk about trade agreements and the resulting obligations. For the MASH sector, which includes municipalities, currently the applicable trade agreements are the New West Partnership Trade Agreement, which is between British Columbia, Alberta, Saskatchewan, and Manitoba, the Canadian Free Trade Agreement between all Canadian provinces, territories, and the federal government, and the Comprehensive Economic and Trade Agreement, which is between Canada and the members of the European Union. In general, all of the trade agreements have 4 key principles of openness, non-discrimination, non-circumvention, and transparency. What are the benefits of procurement? Requirements in trade agreement. Because trade agreements bring with them extensive, complex procurement rules for government entities, it naturally leads to questions of why do we need to do this from those participating in the process. It's a lot of work. Why can't I just go find somebody to do the work? We often hear this. Those are strong reasons why we do enter into agreements that impose the requirements. Reasons are, 1, the importance of providing the best value for our community and public dollars spent, and that is recognized through competition. And 2, that trade agreements, associated procurement process, open doors for our businesses to take advantage of opportunity they may not otherwise have the ability to do. Ultimately, those businesses are allowed to grow and expand as a result of increased opportunity and experience. Trade thresholds. For the MASH sector, 3 applicable trade agreements have thresholds. And each trade agreement has an incorporated threshold, a cutoff above which a procurement tender must be posted publicly. Below that threshold, the tender does not have to be publicly posted for that agreement. A procuring entity can choose to leave a tender opportunity open to those subject to a trade agreement with thresholds below a tender, but it's not required to do so. When considering whether or not a tender should be posted under a particular trade agreement, it's better to err on the side of caution. If it does turn out that the tender exceeds the threshold amount and should have been tendered under that agreement, or in other words, the opportunity should have been made available to those that would operate under the agreement with a higher threshold. If a party learns that they could have bid on the tender and the failure to publicly post takes the issue, the bid protest mechanism can be used to address the situation. An important requirement to keep in mind when considering trade thresholds and their alignment with tender values is that it is clearly prohibited to split tenders in an effort to avoid a threshold. For example, if a project exceeds the threshold amount, it is deemed to be an act of avoiding trade rules and thus a violation of the trade agreement to purposely split the tender associated with one project into smaller pieces. This is another case where bid protest mechanism dispute could be raised because the trade agreement rules were being violated. If a potential bidder on a larger project could make the case there was no reason to split the tender, there can be consequences for the procuring entity. And here's a look at the threshold chart for the MASH sector. While the agreements promote trade, there is a recognition that to require that absolutely all tenders be posted is inefficient. For example, suppose there is a $100,000 tender for janitorial services posted here in Saskatchewan. What are the odds that a European company, one that operates under CETA within the European, is going to submit a tender? Is it efficient or reasonable to open the door for that possibility? Well, not really. To recognize this, each trade agreement has incorporated a threshold, a cutoff above which a procurement tender must be posted publicly. Below that threshold, a tender does not have to be publicly posted for that agreement. A procuring entity can choose to leave a tender opportunity open to those subject to a trade agreement with thresholds below the tender, but it's not required to do so, and this is uncommon. One important factor to consider is what one anticipates the value of the contract to be, or what the contract value is pre-tax. When posting on SAS tenders, when you get to the point of selecting under which trade agreement the tender is subject to, select the agreement with the thresholds for which the anticipated tender amount notably exceeds the threshold. When considering whether or not a tender should be posted under a particular agreement, err on the side of caution. An example of this is a municipality is posting a tender for an anticipated value of a good $150,000 pre-tax. What do they have to consider when assessing under which trade agreement the tender qualifies? And you see there the chart taken from the MASH sector trade values. New West Partnership is 75, CFTA is 121, and CETA is 566. Your tender falls between CFTA and CETA here in the yellow. So as we can see in the threshold table, 150 exceeds New West Partnership and CFTA, but not CETA. When it's posted on SAS tender, both the New West Partnership and CFTA must be marked as applicable. There are some general exceptions, and here's some examples. General exceptions listed exist in multiple, if not all, cases, and you can see them there in the chart of the trade agreements. Unfortunately, what each means is situation dependent. It's not clean cut, which often means the legal support is required to assess whether a procurement falls under these exceptions. Some of those, as you note, measures respecting Aboriginal peoples, not-for-profit organizations, urgent unforeseen circumstances, where it's demonstrated only one supplier can meet the requirement, a commercial resale, specific health and social services. Posting timelines. Trade agreements provide direction on the length of time a procurement competition needs to be posted for. The timelines can vary based on the format of the posting, and some exemptions may apply, specifically with regards to cases in which only pre-qualified suppliers can participate in a tender, commercial goods or services being procured, or if it is an urgent situation. Trade reporting. Reporting is another obligation under the trade agreement. In the CFTA, the Canadian Free Trade Agreement, the transparency rules are outlined in Articles 516 and 517. To begin with, there's a requirement that the procuring entity inform all tender bidders or suppliers of the contract award decision in writing. If an unsuccessful supplier has a question to the decision, the procuring entity is required upon request to explain to the supplier the reasons for their decision. As well, within 72 days of the tender being awarded, the procuring entity is to post those results onto SaskTenders in our case, because that's where your tender was posted, information about the award. This include, but not limited to, the description of the goods and services, the name and address of the procuring entity, the name and address of the successful supplier, the value of the successful tender, and the date of the award. And if limited tendering is used, the conditions and circumstances that justified its use. And around October 15th of every year, the exact date depends on when the weekend falls, an electronic survey is sent from trade agreement and procuring email to all ministries, crowns, and match sectors about a survey on reporting. And I'm not sure who gets that in your municipality, but that does go out because they do collect the data on that. Following the closing of the survey November 30th, the team at Trade and Export Development compiles the data and submits the resulting reports to the required authorities. Reported data is submitted cumulatively by trade agreements and contract type. It is not possible to identify specific procurements by specific procuring entities through these reports, and all data can be captured through the process as there's no privacy or business-related concern. The bid protest mechanism. What happens if you don't follow a trade obligation on the procurement process? When we enter into an agreement, we like to know that we can trust the process that we agree to with our counterparts being followed. The importance of transparency. We want to know that if there's an issue with the process, that we have a way of holding the agreed upon system and our counterparts accountable for their action. As accountability is the main driver for our last topic, the bid protest mechanism. Requirements exist that parties to trade agreements have a mechanism through which a bidder can challenge the process and or the results of a covered procurement process. Such a challenge can relate to various elements of the procurement requirement, not limited to the tendering competition that was posted. The tendering posting wasn't clear in what was expected. Insufficient was time to provide to submit a bid, or inappropriate information applied in assessing a tender offer. Rather than establishing 4 separate accountability tools, the members of the New West Partnership, BC, Alberta, Saskatchewan, and Manitoba jointly created a bid protest mechanism to handle matters. It's often referred to as a streamlined administrative review, working through complaints with the support of an independent arbitrator. There are timelines set out in the process and they can be extended. The parties discuss the matter through a consultation and information sharing. If it's not resolved at that step, an arbitrator is appointed by the parties and the process continues. Tariff cost awards are incurred relating to the dispute resolution process itself and include the costs paid by the supplier for legal counsel, charges for postage, courier, disbursements, tariff cost award $5,000 per dispute. Bid protest costs and circumdemonstratable costs incurred related to the preparation of the bid include material, labor, and other costs, and the maximum bid preparation cost award is $50,000 for all suppliers participating in the dispute related to the specific procurement. Those are examples of some of the costs that can be awarded. It is not a mechanism for accessing lost profits or other forms of contractual or non-contractual damages. As well, this is a legal process and legal counsel is often used by all parties in the process. So time for another checkpoint. What is the municipality's minimum threshold for posting a procurement related to services? 75,121 366.8, or it doesn't need to be posted. The answer is $75,000, the New West Partnership Trade Agreement threshold for services. Question 2. When does a municipality need to report the value of a procurement award on SAS tenders? Is it immediately following the award, within 72 days, or within 1 calendar year? The answer is B, within 72 days of procurement award. This is a CFTA reporting requirement. Question 3. If I only pick one trade agreement with the applicable threshold for my procurement, true or false? And as we indicated, this answer is false. Trade agreement values are stacked when picking for a procurement. Example, you are procuring a good with a value of $375,000. All 3 trade agreements are applicable: the New West Partnership, the CFTA, and CETA. CETA has the threshold of $366,800. You must include agreements below this threshold for that procurement. So this is a high level of procurement obligations for municipalities and many entities. And if you want to have a look at some other links, you can go ahead onto SAS Tenders, the Knowledge Center. There's a link to Buy and Sell Canada. That's the federal site. There's guidelines to the procurement obligations, which is a really great document that Trade and Export Development has put out. That's the one that's right here. The trade agreements are posted. Bid mechanism information is posted. Here's a lot of different topics. Feel free, once the presentation is shared, to go in there, have a look at them, and go from there. If you're interested in other educational sessions, go ahead and visit this link. It was just updated on Monday, which is fabulous. We're all very happy about that. Or you can reach out to me by phone, and I can put you down for any sessions that we have coming up. And incidentally, we just had a meeting that I was in before this. We were talking about scheduling our sessions once a month to be able to have them more accessible to government and to our members, including yourself, and that will be posted. So work in progress and progress being made. So having said that, I went through that in about 35 minutes. Are there any questions? I know it's a lot of really technical information. Some things in there are really valuable for you as municipalities to adhere to and to know. And if I can answer any questions, or you want me to go back to a specific side and chat a little bit more about it, I certainly can do that. So Dustin, I'll take it over to you if there's anything in the chat.
Well, thank you so much, Brenda. And you're right, this is a lot of information, certainly a lot of important information too, and one that affects, I think, so much of the work that is done among elected members. I see there's already a question in the chat, and I'm sure we'll have several. I'll just give that a second for Adam to populate, and then we'll pose it to you. There we go. So there's already a there's already a bit of a kudos to you there, Brenda. This helped someone to understand the trade agreement survey that was completed. So that's really good. In fact, SARM also had to complete the trade agreement survey because we operate a buying group, of course, on behalf of the RMs called member purchasing. There is another question in the chat though, and this one reads, just give me a sec here for it to load in on my screen. There we go. Would you define a contractor that the community uses for digging utility repairs as construction or service?
Oh.
Good question, eh?
It is a very good question. And Yeah, that's a good question. I would probably define that under construction. A service is more of if you are hiring someone to deliver a presentation, just like we just did now. This is a service. If you are hiring a company to come in and do some HR training, that's a service. Because you are involving a contractor and they're actually doing some physical kind of work that involves a good and like, to me, that's construction. So that is a very good question. I would put that in as construction.
Okay, thank you very much there, Brenda. Please do add more comments or questions to the chat. We'll be happy to address those while you've got Brenda on the line here. I do see there's another one that's popped in too. There we go. Brenda, do you have any information regarding requesting a warranty on road construction projects?
If you're requesting warranty on a road construction project, that is something that you would include in your competition document and in your agreement. So whatever contract or agreement that you are entering into with the successful supplier, that's where that would come in. I don't have anything specific to say, oh, it should be holding up for 5 years, or if it doesn't, are you going to be coming back to fix it? I cannot give you specifics on that. That's something I would probably research myself a little bit, like for yourself to research that to see what best practices in other jurisdictions have done, if that is something you can even do. Like I say, I'm not sure, like if it's construction of filling potholes, well, is it just they should last through the season, or they should last for 2 seasons, or should they be 20 years? Well, we all know it's not going to be 20 years. So again, I think that's something that's negotiated within your agreement.
Great. Thanks, Brenda. Another question has come through. Can a municipality tender for heavy equipment without using SAS tenders?
If you're purchasing heavy equipment, is that what you're doing? So you're purchasing a good?
I think that's what they mean there, yeah.
Depends on the value. If it's under $10,000, sure.
Yeah.
If it's meeting, or sorry, the MASH sector, a good $75,000. I was looking at my wrong chart. I'm looking at my chart. So if it's under $75,000, best practice is to get quotes, keep your documentation so that you can back up why you went that way if you have a challenge. If it's more than $75,000, then the next one is 121.2 under CFTA, and then under CETA, it's 366.8. So it depends what the value is.
Right. And would you also say, Brenda, another option for folks is if they go through a buying group, such as member purchasing, that could be a way to avoid and doing all of the work required to tender because it's been done on their behalf already.
Right. That is correct.
Yeah. Okay. Thank you for confirming that, because that's certainly one of the pieces that we at SARM are wanting to support our members in.
Yeah.
And there's another question there about fire trucks. Let's see here. Just wait for that to get posted. Yeah, certainly. We want to encourage our members to come to the SARM member purchasing website to see what sort of vendors and products and goods and services we have programs for. It could be that you won't need to tender for these yourselves, but rather you can access them through the buying programs. Here's that question about fire departments. Are fire department vehicles exempt, and what is the process required for leasing a vehicle? That's a new one for me.
That's a new one. Right off the hop, I'm going to say no, they would not be exempt. Again, you would have to go through the trade agreements and look at exemptions, because there are exemptions of certain things in there. I'm going to jump out and say I do not believe fire department vehicles would be exempt. Leasing, yes, you can lease. You can put your tender out that you're looking to lease the vehicle. I know, we've done some work with that, with buying used equipment or leasing equipment for different, ministries. I can't just think of anything right off the top of my head, but you can structure a competition with a lease. You absolutely can. You just need to make sure that it's very clear that if it's a lease for 2 years and who's going to be responsible for, you know, repairs, breakdown, that kind of stuff. So rather than going right out and making that big purchase, you may want to lease and then have that agreement in place as far as the responsibilities on both ends.
That's great, Brenda. Thank you. Give folks a moment to put any other questions forward that they might have. In the meantime, Brenda, I'm curious from you, if you had to sum up one piece of advice that you'd give to newly elected members of council about procurement in a public sector, what would you say to them? What's the top piece of advice you'd give?
Top piece of advice is document, document, document.
Okay.
Make sure that whatever negotiations you are entering into with whatever type of information you're discussing with your other administrators, document that information. It's so very important that if anything should ever come back to be questioned, you have the documentation to back your decisions and how you arrived at those decisions.
That's really helpful. Yeah, for sure. I guess if things go awry, or if there's a contest, as you mentioned in some of your later slides there, that's why it's important to have all that documentation, because that will help you to make clear to those who might be scrutinizing your decisions why you did what you did.
That's right. Yeah. And that's what we tell our people all the time here, right from the beginning, when they are creating a procurement. It doesn't matter who their client is that they're working with, you document and you keep all of your information. So, and same with all the evaluations, everything is documented. You keep it all.
So Brenda, if there was a RM on our call here today that had questions about procurement, can they reach out to you and your team?
Yes. Yep,
Yeah.
they can absolutely reach out to me. And if it's something that I can't answer, and they want to speak to someone more specific about something with information, I can direct them to who that would be. Now, just because we have our obligation with ministries, we can provide some information to you, but again, we cannot advise you. We cannot say enforce it, do it this way, do it that way, because we don't have that ability to do that with RMs. But you can certainly reach out if you're looking at, you know, scratching your head saying, I don't know which one of these templates I should be using. What is going on here? You know, another thing we really try to emphasize is reach out to some of your other RMs and counterparts and say, what have you guys done with this kind of situation? I don't know if SARM has some type of chat or group where